Welcome to the 2015 Ohio High School Mock Trial State Championship. Good morning. I'm Andy Chow from the Ohio Public Radio and Television State House News Bureau. We're live from the Senate hearing room at the Ohio State House in Columbus. What you'll see today is a polished performance by high school students who will argue a fictional court case live in a real courtroom setting before a panel of judges. What adds to the drama is that all season, each team prepares for both sides of the case, and they only found out a moment ago whether they'll be arguing for the plaintiff or for the defense. Since last fall, teams of high school students have been preparing and competing against one another, and the top two teams have advanced here today for the championship round. Competing today are teams from Ashland High School and Westerville North High School. The winning team today will represent Ohio in the national competition in Raleigh, North Carolina. The sponsoring organization for the Ohio Mock Trial competition is the Ohio Center for Law-Related Education, or OCLRE, which has been educating students about their constitutional rights and responsibilities through this program since 1983. The Supreme Court of Ohio, along with the Ohio State Bar Association, the Ohio Attorney General, and the ACLU of Ohio are OCLRE sponsors. After growing steadily over the past 32 years, OCLRE's Ohio Mock Trial program is the largest non-athletic competition in the state, with about 3,000 students participating and more than 1,000 legal professionals volunteering as legal advisors, case committee members, and judges. Let's watch a brief video produced by OCLRE introducing its high school mock trial program.
Hi, I'm Lisa Eshelman. I'm the Executive Director of the Ohio Center for Law-Related Education, and today we are experiencing day one of the statewide mock trial championships.
It is one of several programs that we sponsor that give students a better understanding of the law and also citizenship and their participation in the democratic process.
The basis of Ohio Mock Trial is to provide students with the opportunity to learn about the Constitution, the rule of law, and our legal system. But students who participate learn so much more than that.
I've participated in mock trial for 4 years now, and it's important to me because it helps me learn about the law and really how our judicial system works.
I've participated in mock trial for 2 years. We actually just brought it back to our school 2 years ago. It was actually through this program that I discovered my love for the courtroom. Before, I didn't have much interest or knowledge of the courtroom or the justice system at all, but it was actually through this program that I decided I wanted to study law and pursue a career in it.
We hear from students who are now adults in all walks of life tell us that the lessons they learned participating in mock trial, they carry with them for the rest of their lives.
Well, I've participated in mock trial for 3 years. I was actually on the original team, which we started 3 years ago, and I love doing it because it really helps me think about analysis of case analysis, and it makes me think about arguments from a completely different perspective after I've done this for 3 years.
OCLRE just runs a great program. I'm impressed every year with their skill at organizing a lot of arrangements, and they put on a great state competition. We've been fortunate to be here a number of times, and things come off really without any kind of a major problem. OCLRE is I think one of the best high school schooling programs that there is.
Mock Trial Day is a lot of fun because we hear the students are working on these cases. Here we actually get to see those who have reached the finals. They're excited, they're well prepared, and as a former teacher, I enjoy seeing excited students.
Well, from mock trial, I've learned so many things. I've learned how to argue, I've learned how to read case law, which is kind of hard. And I've also learned how to present and think on my feet during a trial, so it's been really important.
We support OCLRE because students grow up to be better citizens, well-informed Ohioans, and more engaged in their government and their communities. And that's what it's all about.
watching the Ohio Channel's coverage of the OCLRE High School Mock Trial. I'm Andy Chow. The trial will begin in a few minutes, but before then, let's talk with the Ohio High School Mock Trial Program Coordinator, Priya Santi. Priya, thanks for being here today.
Thank you for having me.
So tell us a little bit about the competition we're about to see today.
Sure. The teams you're going to see are Ashland High School and Westerville North High School. They've been preparing for months, and they are arguing an Eighth Amendment case today. It is about cruel and unusual punishment. A former juvenile inmate is bringing this charge of cruel and unusual punishment against the facility that he was in regarding an implication during a fight that happened, a food fight, and improper treatment. So there's a lot of factual information in the case and a lot of witnesses that could push it one way or the other.
So these teams have been doing this for a couple of weeks, a couple of months now. What are the skills that they're developing as they go through this mock trial competition?
Absolutely. The most important skill that they're developing is really public speaking, being confident in coming up with an argument on the fly, responding to witnesses. A lot of times, even though they've prepared their own witnesses, they have no idea what the witnesses on the other side are going to say. And so sort of being able to develop that skill of coming up with the right question at the right moment in time, that's the biggest skill that they're developing here.
How do you prepare for something like that?
A lot of trial and error, a lot of practice. Not only do the teams play themselves, each side, but they also do a lot of side competitions with other teams, scrimmages, if you will, and they sort of test their ability to respond on the fly like that as often as they can.
You say it's a lot of trial and error, a lot of practice. How much time goes into preparing for mock trials?
Often, most schools will meet once a week for several hours, and during that meeting, initially they're just getting to know the facts of the case, but they really try to hit the element of trial very hard because no matter what the facts are, they're going to have to manipulate them, so they practice very hard, and toward the end, they're meeting multiple times a week for several hours.
When did you say when does the mock trial season start?
The mock trial season starts in September when we release the case. And so about the third week of September, once all the students and the teachers receive the case, they start going through the facts. And then the first district competition is in January. So they have from September to January to start beginning their practice.
So since September, how many teams have competed in this competition?
323.
And today we're seeing the best of the best then?
The best of the best, the top two, yes.
Can you tell us a little bit about the teams we're seeing today?
Sure. Both Ashland High School and Westerville North High School have never made it to the final championship round. So it's extremely exciting that they have be able to be a part of this. So both Westerville North and Ashland High School have consistently been among the top 4 teams. So they've been sort of front runners, but they both have they bring something to the competition that I think we don't usually see. They both have a finesse to their style. They're not very aggressive, and I think that's a really different and good thing to see for the judges.
So it really showcases a student's legal knowledge, but are we going to see some dramatic elements involved too, some theatrics?
Certainly, yes. Among some of the star witnesses, we have a doctor who treated the plaintiff who's bringing the case and a nurse who treated the plaintiff while they were at the facility, and they both have very different opinions about what the injury was. We also have a former inmate testifying, and so there's going to be a lot of he said, she said, and that is really going to contribute to what the attorneys can pull from the witnesses and make in their arguments.
What happens when the whole competition is over and a winner is announced? What does that winner do after this?
The winner will get to represent Ohio at the national championship in Raleigh, North Carolina in mid-May.
Okay, great. Priya, thank you so much for being here today.
Thank you.
Let's learn more about the specific facts and legal issues presented in this year's case that the students will be arguing in just a few minutes. The case is titled Emerson Jones versus Buckeye Juvenile Correctional Institute. Let's talk with Lisa Eshelman, the Executive Director of OCLRE. Lisa, thanks for being here today.
Oh, absolutely. It's exciting to be here today.
Tell us a little bit about the case that we're going to see argued today.
Certainly. Today Emerson is a plaintiff, and he is a juvenile incarcerated at the Buckeye facility on a robbery charge. One day during his incarceration, a fight or a riot broke out, and Emerson sustained an injury. It's alleged that he was thrown down to the floor by one of the guards, Menendez. As a result, he was looked at, evaluated by the in-house physicians and nurses at the facility, and they determined it was a sprain. After Emerson was released from Buckeye, it was determined that his wrist was actually broken. The significance of this is that he has a permanent injury now. He was a star athlete in high school and played basketball, and he alleges that because of his injury, his basketball career is now over.
So this is a fictional case.
It is. Each year, the Ohio Center for Law-Related Education, through its case committee, creates an original case file based on a constitutional issue.
And so you picked this fictional case to try to bring out some legal issues. What are the legal issues we're going to see argued here today?
Certainly. Today's case is based on the 8th Amendment of the U.S. Constitution, which prohibits cruel and unusual punishment. So the plaintiff in this case, Emerson, has alleged that the facility violated his 8th Amendment rights by causing his injury and also failing to properly diagnose his injury. The defendant in this case is the Buckeye Juvenile Correctional Facility, and they've indicated that the guard Menendez used reasonable force in order to contain the riot or the fight that broke out in the cafeteria. And so they allege that they didn't violate his 8th Amendment rights.
What goes into picking a scenario like this? You want to get something that kids will be interested, that high school students will be interested. What goes into something like that?
We are so fortunate that we have a case committee that gathers every spring, and they're made up of lawyers and judges from around the state, and they do exactly what you have suggested. They look for cases and fact patterns that we believe are going to be of interest to high school students. So whether or not it's something that's happening in the United States or around them, or whether or not it's an issue that they confront in their schools every day, that's usually the starting point for each year. And then we look at the various possibilities for which amendment or which part of the U.S. Constitution will be the framework for that case.
What else do you think viewers who are watching at home should know about the case as we prepare to watch the mock trial state championship?
Well, what we have heard from the teams coming up since January is that this is a really hard-fought battle, that equally the same number of teams have won as the plaintiff as they have as the defendant. And that's always fun when you're looking at the trial for the first time. So it's going to be a very exciting match.
Seems pretty complex, too, then.
It is, when you think the fact we have 2 out of 3 witnesses who are lay witnesses, but there's also an expert witness, which is a doctor. And so the students had to learn how to properly prepare and examine a professional expert. And putting all those moving and parts together, they have to decide which facts are most important, which facts are in conflict with other, and how do you work around those particular facts to make a cohesive argument.
So it should be fun to watch, huh?
Oh, it's going to be a great day.
Great. Lisa, thank you very much for being here.
Thank you so very much.
Yep. We'll get to hear from Lisa again after the trial while the judges deliberate and score the teams. We look forward to hearing for her analysis on how the students perform. Next, let's talk to Ryan Susky, Director of Professional Development at OCLRE. Ryan, thanks for being here today.
Thank you for having me. Good morning, Andy.
Tell us a little bit about professional development at OCLRE, what OCLRE does.
Sure. Well, OCLRE is Ohio's statewide civics education organization. So we run a variety of programs for teachers and for students to really help them understand the legal process, the rights that students have, really just kind of getting an insider's view of what our government looks like and how they can become an active and engaged citizen.
How does that relationship work? How is that beneficial for both sides?
Absolutely. It's good for OCLRE to really have a chance to work with the students and also the teachers, and we really hope that we can, provide the information that students need. For us, we learn from the students and all the things that they bring to the table, the interesting perspective the students have about our government and about the law. And additionally, the teachers, they really get resources they can use in the classroom to fill in some of those gaps that maybe they might not have as much training for, or the curriculum might not be as solid. So we're always happy to help provide teachers with those resources and materials.
Can you tell us a little bit more of the specific programs that you might host?
Absolutely. So OCLRE is really a broad range of programs. We have programs for students from elementary school up to high school. We have programs on the law side and also on the civics and government side. So, for example, we have a program called We the People, which we do for middle school and high school students. We the People is a program that turns students into constitutional experts. So they go through a process of curriculum and they end up walking out of there as expert witnesses at a congressional panel. We also have programs that sit on the law side like mock trial. We have mock trial for middle school and for high school. Our mock trial middle school case is actually a lot of fun. It's always based on popular literature. So this year students will be facing off as the animals of Animal Farm, deciding if the pigs, Napoleon and the rest of the pigs, have violated the commandments of animalism. And we also have a program called Moot Court. Moot Court is kind of the next step up from mock trial. So students are being asked to take on an appellate case and look at the constitutional issues involved in an appellate case. And the last aspect would be we have programs that ask students to get involved in their communities and in the government. They're Youth for Justice and Project Citizen. In these programs, students, they identify an issue in their community they'd like to solve. So it starts with kind of that problem-based thinking and strategic thinking skills. And the students try to find a creative solution for that problem, and then they work with their local government or local decision-making body, say at their school or in their community, to try to get a resolution of that issue they've identified.
So it sounds like all those programs are very beneficial for students and everything. How do you approach students on teaching them about law?
Sure. So the first thing we start with is trying to figure out what for students is going to be interesting, right? So what are the things that students would enjoy learning about, or students would like to get involved with. From there, we also start thinking about, what's current in the law right now. So as Lisa mentioned, this year's case is an Eighth Amendment case. And often people think of Eighth Amendment, they think about death penalty or cruel treatment in a prison. But we felt like the law, there's so many more interesting things to talk about the law, and the students really need to get a full perspective. And so for that reason, the case this year goes in a different direction, with the idea of the excessive force and delay of medical treatment. So.
Okay, great. Well, very interesting. Thank you very much for joining us today. Now that we've explored the details of the competition and the case, it's time to learn more about the competing teams. Arguing for the plaintiff, Emerson Jones, is Team Red from Westerville North High School. This is the team's first time at the state championship, and it was in the top 4 in 2012. The team has 10 students. For the defendant, Buckeye Juvenile Correctional Institute, Team Darrow from Ashland High School. This is Ashland's first time at the championship as well, but it was in the top 4 last season. The team has 7 students this year. We wish both teams the best of luck, and we look forward to seeing their hard work pay off in the championship round today. The trial should be starting in just a few minutes, but while we have the chance, let's talk about this beautiful room and its history. As you know, we're coming to you from the Ohio State House in downtown Columbus. This room is a hearing room for the Ohio Senate, but it used to be the law library, so it's appropriate setting for this mock trial. Additionally, the Ohio Supreme Court used to hold its sessions in the room directly above us, in what's now known as the North Hearing Room for the Senate. Today, the Ohio Supreme Court has its own building, the Thomas J. Moyer Ohio Judicial Center, just a few blocks away from here on Front Street. Again, you're watching the Ohio Channel's coverage of the 2015 Ohio High School mock trial. Ashland High School and Westerville North High School are about to argue the fictional case, Emerson Jones versus Buckeye Juvenile Correctional Institute, about an inmate whose wrist is fractured by a guard during a fight. Jones brings a claim against the institute, alleging it violated Jones's Eighth Amendment right to be free from cruel and unusual punishment. The mock trial should last about an hour and a half before the judges take a break to score the teams. At that time, we'll be back with more information and interviews, including with some of the students. Let's go now to the main floor of the courtroom.
We would like to
This is the trial of Emerson Jones versus Buckeye Juvenile Correctional Institution. My name's Jerry McBride. I'm a judge in the Court of Common Pleas in Claremont County, a member of the Mock Trial Competition Committee, and also a district and regional coordinator. Will be the presiding judge in this competition, and I'd like all the scoring judges, if they would introduce themselves. We'll start at the left side.
Thanks, Judge. I'm Jeff Ginsburg. I'm an attorney from Holmes County and chair of the competition committee.
I'm John Hsu. I'm an attorney with the Ohio Environmental Review Appeals Commission and one of the co-chairs of the case committee.
Good morning, everybody. My name is Lee Bellardo. I'm an attorney, and I'm also president of the Ohio State Bar Foundation. Last fall, we awarded over $500,000 to grantees, including OCLRE, to meet our mission of promoting the pursuit of justice and the public understanding of the law.
Good morning, everyone. My name is Drew Dennis, and I am a staff attorney with the American Civil Liberties Union of Ohio.
Good morning. I am Edmund Sargis. I'm the Chief Judge of the Federal District Court here in Columbus.
Morning to everyone. I'm Alan Goldsberry, just retired from the General Division of the Athens County Common Pleas Court.
Good morning, everyone. I'm from Cincinnati. My name is Steve Jemison. I'm the CEO of the Law and Leadership Institute and retired lawyer from Procter & Gamble.
Are both sides ready to proceed?
Ready to proceed, Your Honor.
Mr. Waldroff, you may proceed then.
Yes, Your Honor. Before time begins, I would like to introduce myself and my team. I'm Jacob Waldroff, and I'll be opening for the plaintiff, and my co-counsel, Jacqueline Cluse, will be closing. Today we will call two witnesses. First, Emerson Jones, played by Amy Cox, and second, Dr. Jamie Lawrence, played by Matthew Spadaro. May it please the Court. Your Honors, we all have responsibilities. I have responsibilities to my clients, and doctors have responsibilities to their patients. Now, the Buckeye Juvenile Correctional Institution has responsibilities too. BJCI's guards were hired to protect inmates. Their medical staff was hired to treat them. But the staff of the Buckeye Juvenile Correctional Institution shrugged off their responsibilities. They blatantly disregarded their basic constitutional obligations, and one young woman paid the price. In today's case, a minor conflict between inmates over the food served in their cafeteria led to a confrontation. The violent overreaction of the guards, including Guard Mendez, left Emerson Jones, a former inmate at BJCI, with a wrist injury which will prevent her from ever pursuing a career in basketball. Now, Emerson will tell you that she did not participate in the fighting that day. The evidence will show that she was simply trying to stay out of it, and only when the food fight was all but over did Guard Mendez grab her wrist and pull her forcefully to the ground. Now, far from acting to preserve order, Emerson will tell you that guard Mendez actually broke her wrist in retribution. The guard has a history of harassing Emerson, and his harassment escalated throughout her 4 years at BJCI. It began soon after she arrived, when guard Mendez caught Emerson crying in her bunk. She just missed her family, but the guard was so ruthless in his teasing that a month before the food fight, Emerson had no choice but to turn to the warden, and the harassment stopped until the day that he broke her wrist. Now, several days after the food fight, Emerson's pain continued to worsen, so she went to the infirmary. She told Nurse Rogers that a guard hurt her wrist, but the nurse insisted that she'd injured it in a fall. The evidence will show that Nurse Rogers didn't ask any questions and that she had little more than a grainy x-ray when she determined that Emerson's wrist was sprained and told her to wear a brace. Now, Dr. Jamie Lawrence, who has been a practicing orthopedic specialist for 22 years, will tell you that the nurse's diagnosis was improper because she should have ordered an MRI, consulted with a physician, and only then ruled out a break. Soon after meeting with the nurse, Emerson was released from BJCI. When her pain did not get better, she went to see Dr. Lawrence, who determined that her wrist was broken and performed a surgery to reset the bones. Dr. Lawrence will tell you that he did all he could to facilitate Emerson's recovery, but she will never regain full function of her wrist. Now, we have the burden of proof in today's case based on a preponderance of the evidence. And at the end of this trial, we will have satisfied that burden by proving two things. First, we will prove that BJCI's medical staff was deliberately indifferent to Emerson Jones' serious medical needs because they knew or inferred a serious risk of harm. They disregarded that risk, and it was this lack of action that caused Emerson's lasting injury. Now, second, we will prove that guard Mendez's actions were unnecessary and wanton because he did not act in good faith to restore order, and in fact, his intent was to cause Emerson harm. To this end, we will call two witnesses. First, Emerson Jones will testify that guard Mendez injured her maliciously to get revenge and that she received only a cursory medical examination and disinterested treatment. Second, Dr. Jamie Lawrence will examine Emerson's medical treatment, and through his testimony, we will show that BJCI's medical staff was deliberately indifferent to Emerson Jones' serious medical needs. Now, each of us has responsibilities to one another, Your Honors. Our system can't function if we evade them. The staff of the Buckeye Juvenile Correctional Institution didn't just evade or overlook or forgo their responsibilities. They blatantly disregarded them. BJCI institutionally abandoned its responsibilities to Emerson Jones, and it must be held accountable. Therefore, we respectfully request that you find the Buckeye Juvenile Correctional Institution liable for violating the Eighth Amendment rights of Emerson Jones. Thank you.
Thank you very much. Mr. Gruber, you may make your opening statement.
Before I begin, Your Honor, I would like to introduce my team. My name is Ethan Gruber. My co-counsel is Bharat Venkataramani. Playing the part of Casey Burgundy is Lexi Portner. And playing the part of Blair Healy is Noel Burke. Your Honor, opposing counsel, may it please the court. Buckeye Juvenile Correctional Institution, which we will now refer to as BJCI, has an obligation to see to the safety and well-being of all inmates. We are here today because plaintiff Emerson Jones alleges that her Eighth Amendment rights of protection from cruel and unusual punishment were violated when she was subdued and prevented from further participating in a prison riot, and subsequently, for the diagnosis and treatment she received for the wrist injury she sustained during that riot. Emerson Jones was recently released from BJCI after serving a 4-year term for aggravated robbery. During her time at BJCI, plaintiff became affiliated with a prison gang. Along with provoking numerous gang-related confrontations, plaintiff incited a food fight in the BJCI cafeteria that eventually escalated into a full-scale brawl between inmates. The safety and well-being of inmates and staff were at risk, and the guards acted accordingly. Immediately after the onset of the riot, senior guard Casey Burgundy ordered all inmates to get to the side of the room and against the ground, an order which is routine for inmates at BJCI. However, plaintiff ignored this order and instead opted to continue to throw food and inflame the riot. A second command to get down against the wall was given by guard George Mendez to the plaintiff. However, plaintiff ignored yet another order and instead opted to launch yet another projectile to encourage the chaos in the BJCI cafeteria. In an attempt to restore order, Guard Mendez grabbed plaintiff's throwing hand and forced her to the ground, effectively subduing the threat and restoring order to BJCI. After the riot was subdued, several inmates, along with the plaintiff, were taken to the infirmary to receive medical care for their injuries. Plaintiff neither requested nor received treatment at this time and was taken back to her cell. In the subsequent days, the plaintiff approached Senior Guard Burgundy about pain in her wrist, and she was taken to the infirmary where she received diagnosis and treatment for a sprained wrist. Now, the court has asked us to examine the alleged Eighth Amendment violation of the protection from cruel and unusual punishment. There are two questions before the court today. One, was there excessive force used against the plaintiff? And two, was there deliberate indifference to the medical needs of the plaintiff? To answer these two questions, the defense will call two witnesses. First, we will call Ms. Casey Burgundy, a senior guard at BJCI. Ms. Burgundy will testify to the need for order at BJCI, BJCI's guidelines for the use of force, and Ms. Burgundy will provide an account of plaintiff's visits to the infirmary. Second, the defense will call Ms. Blair Healy, an inmate at BJCI that was present for the riot. Ms. Healy will present plaintiff's inflammatory behavior, plaintiff's involvement with gang activity at BJCI, and Ms. Healy will testify to what she saw occur during the riot. With the testimony of these two witnesses, the defense will prove that, one, there was no excessive force used against the plaintiff, but rather BJCI applied minimal force in a good faith effort to restore order and discipline, and two, there was no deliberate indifference to the medical needs of the plaintiff, but rather BJCI responded appropriately to all known medical concerns presented by the plaintiff. Now, the plaintiff has the burden of proof today, but through the presentation of our evidence, the defense will show that the plaintiff did not meet this burden, and therefore we will ask the court to find in favor of BJCI and dismiss all charges against the defendant. Thank you.
Thank you. At this time, I'll ask all of the witnesses who will be testifying to step forward and ask the bailiff if she would swear in the witnesses.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, and that your testimony will comply with the rules of the Ohio Mock Trial Constitution? Yes. You may be seated.
Mr. Waldrop, on behalf of the plaintiff, you may call your first witness.
Yes, Your Honor. The plaintiff calls Emerson Jones to the stand. Whenever you're ready, Ms. Jones, could you please introduce yourself to the court?
Absolutely. My name is Emerson Jones.
How old are you?
I am 21.
How long were you at the Buckeye Juvenile Correctional Institution?
I was at BJCI for about 4 years.
Why were you there?
Honestly, I was just in the wrong place at the wrong time.
What do you mean by that?
Well, you see, I was shopping at this corner market when a group of my so-called friends decided to jump in and rob the place. I had no idea this was going on, and I was terrified, so I ran. Because I ran, I was the only one they could identify, so I'm the one who got booked for it.
Now, what sort of things did you do before you were at BJCI?
Well, mostly, I spent my time playing basketball.
Objection, Your Honor. I don't see how the issue of playing basketball is relevant to the liability phase of the case today.
May I respond, Your Honor?
Yes.
This basketball is laying foundation to show the seriousness of the injury and the lasting nature of that injury, and it is relevant to go to the nurse's treatment of Emerson Jones' injury.
May I respond, Your Honor?
Yes.
This clearly goes to damages if it goes to the nurse's treatment and how it will affect her in the future. We are here about liability and not about damages.
May I respond, Your Honor?
It has some relevance at this point. I'm going to overrule the objection.
Yes,
Thank you, Your Honor.
Did you finish your answer?
No, I didn't. I spent most of my time playing basketball. I was born to be out on that court. Basketball was my life.
Were you any good?
I was pretty good. I started seeing scouts freshman year of high school. I even received a few international offers.
Now, will you pursue those international offers now that you're out of BJCI?
Well, I wanted to, just to keep playing, but with the condition my wrist is in, I can hardly dribble, let alone play professionally.
We'll come back to your wrist in a minute, but first, let's talk about BJCI. What was it like?
The conditions definitely weren't the greatest, but I thought it would have been almost tolerable if we had some decent food to eat. So a few other people who thought the same as I did started petitioning the warden for more hamburgers and french fries.
How did your petition go?
It barely even got off the ground before another group started petitioning for more fruits and vegetables. I didn't personally understand this because that's pretty much all we had anyway, but both of our groups kind of understood only one petition would be granted.
So what happened?
The whole C block picked sides. Everyone was either with the veggies, which is what the other group called themselves, or the Big Macs, which is what we called ourselves.
Now let's move on to the day of the food fight. How did that day start?
That day, my pants ripped, which wasn't any surprise. When I went to ask one of the guards on duty, Guard Mendez, if I could have a new pair, he gave me ones that were way too long. I asked if I could have a pair that was a little shorter, but he just told me to quit whining and roll them up.
This is hearsay. Guard Mendez is not here to testify today.
May I respond, Your Honor?
Yes.
While this testimony is hearsay, it is an exception to hearsay because it was an admission by a party opponent.
Your response?
Guard Mendez is not here today to offer testimony in this matter, and it is still hearsay.
May I respond, Your Honor?
Sure.
Regardless, Guard Mendez is a party opponent. He was a representative of the Buckeye Juvenile Correctional Institution.
Objection to be overruled.
Thank you, Your Honor.
Did you finish your answer?
Yes, I did.
So did you roll your pants up when Guard Mendez told you to?
I had to. They were so long, honestly, it came down to rolling them up or tripping over and hurting myself, which wasn't going to happen.
Well, now I'd like to talk to you about your relationship with Guard Mendez. What was your first interaction with him?
I believe my first interaction with Guard Mendez was when I first arrived at BJCI. To put it lightly, jail wasn't ever in the plans, and I had no idea how to deal with being in an institution, let alone with all these scary inmates who actually did something to get into jail, and I just missed my family, and Guard Mendez caught me crying in my bunk. As if that's not embarrassing enough, he decided to tell all the other inmates. He even gave me tissues whenever he saw me.
How long did that go on?
Well, it began when I first arrived at BJCI, but it didn't stop until a month before the food fight when I finally was so tired of ignoring it that I had to do something, and I told the warden about it.
Well, after you talked to the warden, did you have any other problems with Guard Mendez?
The next biggest problem I can think of was the day of the food fight when my pants ripped and he refused me something as simple as a shorter pair.
Later that day, during the food fight, what happened?
That was when I was in the cafeteria. I wasn't even involved in the food fight when Guard Mendez came out of nowhere and slammed me to the ground.
Did you get any sort of warning from Guard Mendez?
No, absolutely not.
Do you know why he threw you down?
No. At that point, the food fight had pretty much died down, and I hadn't even involved myself in it.
Could you describe for the court exactly how Guard Mendez threw you to the floor?
Absolutely. I was just standing in the middle of the cafeteria when, out of nowhere, this full-grown man comes barreling towards me, grabs me by my wrist, and slams me to the ground. I had a sharp pain as soon as I hit the floor.
Well, let's talk about that. How did your pain turn out?
Well, I had hoped it would go away, but a few days later it was still really bothering me, so I asked Senior Guard Burgundy to take me to the medical wing.
I want to make sure that I understand your testimony. Were you taken to the infirmary on the day that you injured your wrist?
I was, but I didn't receive any treatment whatsoever, not for my wrist or anything else, so I assumed the pain would go away.
So when you went back a few days later, what happened?
That was when I met with the nurse. I tried to explain to her how my wrist hurt really badly, but she just couldn't seem bothered to listen to what I had to say. I even asked her if I could see a doctor.
This is an improper opinion. Ms. Jones cannot testify as to the nurse's state of mind.
May I respond, Your Honor?
Yes.
Pursuant to Evidence Rule 602, the witness was simply giving her perceptions of the nurse and giving her opinion on that basis. She wasn't testifying that the nurse necessarily believed that.
Objection is sustained.
Thank you, Your Honor.
Now, Ms. Jones, did you know how you were to deal with your injury?
After I tried to explain for the second time how my wrist hurt really badly, the nurse interrupted me this time and then just gave me a brace to wear.
Did wearing a brace help?
Absolutely not. I was still in really bad pain quite a few days later.
So did you see someone else about your injury?
Yes, I did. After I left BJCI, I went to see a specialist who would actually listen to what I had to say.
Who was that?
That was Dr. Lawrence.
What was his conclusion?
He told me that my wrist was broken, not sprained.
Well, I just have a few more questions for you. First, how has your injured wrist affected your life?
Well,
This goes to damages and not liability. I don't see how it's relevant today.
May I respond, Your Honor?
Yes.
This goes to the lasting nature of Emerson Jones' injury, and it is relevant as it shows the omissions of the nurse in her treatment.
May I respond, Your Honor?
Sure.
The lasting nature of the injury is damages, and we are here today about liability.
I agree with the objection. The objection will be sustained.
Yes, Your Honor. Now, did you do anything that you know of to provoke Guard Mendez?
absolutely not. The food fight was pretty much over when he came in, and I hadn't participated in the food fight at all. The only thing that I could think of was that the month before I told the warden that he was harassing me.
Did you have a follow-up visit with Nurse Rogers after she diagnosed your injury?
No, I didn't.
And finally, why did you bring this case against BJCI?
I blame BJCI for breaking my wrist and ending my basketball career. Nurse Rogers should have done her job and listened to what I had to say instead of just, in my opinion, she just assumed I was faking it.
Objection, Your Honor. This is speculation.
May I respond, Your Honor?
Yes.
Pursuant to Rule 602, the witness was simply giving her perceptions of Nurse Rogers. She wasn't testifying that necessarily Nurse Rogers actually did assume that she was faking.
Objection is sustained.
Thank you, Your Honor.
Could you tell us any other reasons that you brought this case against BJCI?
Yes, absolutely. I also blame Guard Mendez. I didn't do anything in the food fight. I didn't even participate in it when he slammed me to the ground and broke my wrist. And finally, I didn't see BJCI do anything to correct any of this.
Thank you, Your Honor. No further questions.
Mr. Von Cotter-Romani, you may cross-examine the witness.
Yes, Your Honor. Your Honors, may I proceed?
You may.
Ms. Jones, you were incarcerated in BJCI for aggravated robbery, correct?
Unfortunately, a crime I did not commit.
And you claim you weren't guilty of that crime, right?
Objection, Your Honor. I request that you instruct opposing counsel to allow my witness to finish her answer.
You do have to let her finish her answer before you proceed to the next question.
Had you completed your answer?
No, I did not. As a crime I did not commit, unfortunately, I was assigned to an institution for that, yes.
So, we heard your claim that you weren't guilty, but the court disagreed with you and sentenced you to 4 years in BJCI, correct?
I don't know what the court was thinking because I wasn't a part of the court, and I just, in my own opinion, I don't believe they had any other evidence but the misidentification of me.
Your Honor,
so, yes,
I'd like to strike the last part of that answer as an improper opinion. I did not ask as to her mindset in the courtroom.
May I respond, Your Honor?
Sure.
The witness was simply giving her opinion based on her perceptions, and it was a lay opinion pursuant to Rule 701 that is admissible.
The answer was not responsive to the question. I'll require Mr. Von Cotter-Romani to not ask questions until the answer is finished, but the answer needs to be responsive to the question.
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. Would you like me to repeat that question?
Yes, please.
The court sentenced you to 4 years in BJCI, correct?
Unfortunately, they did, yes.
And you served the entire 4 years in the institution, right?
Yes, I did.
Now let's talk about BJCI on the inside. The institution ran on a certain schedule every day, right?
I don't believe so, no.
You don't believe that they had certain times each day for your meals and recreation?
We did have scheduled times for meals, and occasionally we got to go to a recreation area, but the rest of the day was pretty jumbled.
But those were scheduled?
Those two were, yes, specifically.
And BJCI even has a set of rules posted on a board in big bold letters, correct?
Yes, they do.
And you've seen these rules hung on the board, haven't you?
I have, but the institution doesn't really follow them.
And BJCI had guards as well to enforce these rules, correct?
To me, it seemed like they didn't enforce them at all, but they had the rules, that's correct.
But regardless, they had guards?
They did have guards, yes.
So, Ms. Jones, because you had set times for your meals and your recreation, and you had these rules posted on the board, and you had these guards to enforce the rules, we can agree that there is order in BJCI, right?
Honestly, I wouldn't say so. The guards don't follow the rules in the institution, and things do happen, so I don't believe there is order, no.
So no, you don't think there's order?
Not all the time, no.
Now let's talk about the riot in the BJCI cafeteria. You were present for that, weren't you?
Objection, Your Honor, to the use of the word riot as unfairly prejudicial.
Your Honor, I'm not being unfairly prejudicial. It was a prison riot.
May I respond, Your Honor?
Yes.
No foundation has been laid whatsoever to show that this altercation in the cafeteria was, in fact, a riot.
I'm going to sustain the objection. You can ask your question, just ask it differently.
All right. Ms. Jones, there was a food fight in the BJCI cafeteria, correct?
Yes, there was.
And you were present for that?
Yes, I was.
And the cafeteria was in a state of, as you describe it, chaos, right?
Whenever you get inmates in any sort of room, things get chaotic, yes.
But yes, it was chaotic.
Yes.
Inmates were running around the room, pushing each other, throwing food, and some were even throwing punches, weren't they?
I did see people throwing food. I believe I might have saw people getting a little violent, but I'm not sure. Things were going around pretty quickly.
Ms. Jones, in BJCI, isn't there a way to signal that you're not involved in a fight to go to the wall and sit down?
No, absolutely not.
No, there's no such way?
No, in BJCI, these are inmates, and a lot of them did really bad things. If you're going to be in the same room as them, they don't care if you're sitting down or standing up. They're going to start the food fight.
So, Ms. Jones, yes or no? Well, there's no way to signal that you're not part of a riot or food fight?
In my opinion, no. I don't believe there is.
Now, Ms. Jones, we talked about these rules in BJCI. Is there a rule in BJCI that allows you to go to the cafeteria and throw food at whomever you want?
Honestly, I don't know all the rules. I have never seen that one, but I've never seen anything against it either. I don't know.
Is there a rule that allows you to go to the cafeteria and run around as wildly as you possibly can?
I'm not a guard, and the rules in BJCI, I don't know if that's all of them, but I don't believe there would be a rule against that, no.
So you don't know if there is one?
No, I'm not a guard.
Ms. Jones, is there a rule in BJCI that allows you to go to the cafeteria and just punch whomever you want?
Objection, Your Honor. This question calls for speculation.
Your Honor, I'm not asking the witness to speculate. Pursuant to the simplified rules of evidence, the cross-examination may inquire into any relevant omissions, and the witness may make reasonable inferences based on these relevant omissions.
May I respond, Your Honor?
Yes.
Opposing counsel has laid no foundation at all, even to show that Ms. Jones has any knowledge about the rules, let alone that she would know what specific rules are.
Objection to be overruled.
Ms. Jones, would you like me to repeat that question?
Yes, please.
Is there a rule in BJCI that allows you to go to the cafeteria and just punch whomever you want?
Like I said, I don't believe I even know half of the rules, let alone all of them, but I believe that there's nothing against it.
Now, when the guards came into the cafeteria, they weren't silent, were they?
Honestly, I didn't. In the beginning, they came in a little rowdy, yes.
And isn't it true they were actually shouting orders?
I honestly did not hear any orders specifically, but they were being very loud.
So, yes, they were being very loud?
They were being loud, but I didn't hear any orders whatsoever.
And Ms. Jones, you said that you were in the middle of the cafeteria. You were trying to concentrate on something your teacher, Ms. Caputo, was trying to motion to you, right?
Yes, I did see Mrs. Caputo motioning to me.
And it was at that time that you were taken to the floor, right?
I was slammed to the ground by Guard Mendez, yes.
Now, Ms. Jones, you think you having to roll up your pant legs caused this riot to occur, right?
Absolutely not. I have no idea what caused the food fight. I wasn't involved, and I don't even know who started it.
But when you got those ill-fitting pants, you had no idea of the availability of uniforms, did you?
No, but I mean, it's an institution. Clothing is a basic right. I would believe that they would have enough clothes to fit us.
So no, you had no idea of the availability of uniforms?
No, I don't, but I would hopefully assume that they did.
Your Honor, I would ask that you instruct the witness to answer the question asked. I have phrased them in a yes or no fashion.
May I respond, Your Honor?
Yes.
My witness did answer the question.
Yeah, I think the answer was responsive.
Thank
you. You can proceed to the next question.
And Ms. Jones, you were upset with the pants you got. Yes or no?
I wasn't upset with them. I wouldn't say that. I wish I got a shorter pair, but I wasn't angry about it or anything.
But regardless, you didn't want longer pants. You wanted the shorter ones that would fit, right?
I did want shorter pants. That's correct.
Now, after the chaos in the cafeteria had subsided, you went to the BJCI infirmary, right?
I believe I did go to the infirmary afterwards, yes.
And a few days after that, you asked Guard Burgundy if you could go back to the infirmary, right?
I didn't receive any treatment the first time, but my injury didn't go away, so yes, I absolutely did ask to go.
Did you return more than once?
I went to the infirmary 2 times.
And each time, a nurse examined you, right?
I don't understand what you mean by examination.
Like, you were seen by a nurse, right?
I was seen, but I wouldn't call it an examination by any means. She just kind of looked at it. She didn't ask any questions.
But she gave you a brace to immobilize your wrist, didn't she?
She did, yes.
And every time you went to the infirmary, you were seen by the nurse and told to continue resting and wearing your brace, right?
I don't believe she ever specifically told me to rest. She said that resting might help it. But she gave me the brace the second time I visited. I didn't receive anything the first time.
Now, let's go back to the cafeteria for a second. Do you recall that you said that you were in the middle of the cafeteria?
Yes, I was. That's where I was talking to some friends when it started, so that's where I was.
And it was in the middle of the room that Guard Mendez pulled you down to the floor, right?
I believe that was about where I was, yes.
But, Ms. Jones, this injury really is not about Guard Mendez and his attempts against you. It's really about you disobeying those orders and rules you were expected to follow. Isn't that true?
Objection, Your Honor. Form of question.
You want to expand on that?
Yes, Your Honor. Opposing counsel was asking my witness to make a conclusion that she simply can't make.
Your Honor, I'm just asking the witness to make an inference.
This is cross-examination. I'll permit the question.
Yes, Your Honor.
Ms. Jones, would you like me to repeat that question?
Yes, please.
This injury really is not about Guard Mendez and whatever intent he had against you. It's really about you disobeying those orders and rules you were expected to follow. Isn't that true?
Absolutely not.
Thank you. No further questions, Your Honor.
Redirect, Your Honor.
Go right ahead.
Before I begin with my other questions, I'd just like to ask you, do you want to finish that last answer?
Yes, please. If that's all right.
Go right ahead.
I don't believe that that's what it was about whatsoever. Honestly, I didn't hear any orders from any guards. If I did, I would have complied. I wasn't a part of the food fight, so I didn't hear anything or have anyone talk to me personally whatsoever.
Now, you were asked about the rules at BJCI. Do you know all of the guards' rules?
No, absolutely not. I know the 2 or 3 that are posted, but I'm assuming that it's a prison, so there must be other rules than that.
You were also asked about the food fight that started. Do you know why it started?
No, absolutely not. People have anger issues in this institution, and they get riled up over the stupidest things. It could have been because someone didn't...
Your Honor, this is speculation.
May I respond, Your Honor?
Yes.
My witness didn't offer any speculative testimony.
They get riled up about what was the last thing she said?
I believe it was they get riled up about these issues, Your Honor.
Objection is sustained.
Thank you, Your Honor.
Now, during the food fight, did you believe that it was a serious issue?
Honestly, no. I had food fights in elementary school. I didn't think it was dangerous. I didn't think that it was going to hurt me or anyone else. If I would have saw it getting into, like...
Your Honor, this is not fair extrapolation.
May I respond, Your Honor?
Yes.
The witness wasn't extrapolating from her statement. She was simply saying that she didn't believe it was dangerous.
And where is that in the witness statement?
Just a moment, Your Honor. I'm not sure that it is in the statement, Your Honor.
Objection will be sustained.
Thank you, Your Honors.
Now, Ms. Jones, why didn't you go to the wall during the food fight?
I saw no reason to go to the wall, but even if I did, everything was happening pretty quickly. I didn't have any time to move.
You were also asked about your treatment at the infirmary. Did you receive treatment the first time that you went?
No, I didn't receive any type of treatment or advice even to just see if it hurt and came back. She didn't really tell me anything.
What about the second time?
The second time, I went to the nurse and she just kind of looked at my wrist. She didn't ask any questions. She poked at it maybe once, and then she ordered an x-ray.
What treatment did she give your wrist at that second examination?
She only gave me a brace to wear.
Did that help?
No, absolutely not. The only relief I got was after the surgery performed by Dr. Lawrence.
Thank you, Your Honor. No further questions.
Any recross?
Yes, Your Honors. May I proceed?
You may.
Ms. Jones, you said that this was a serious issue and that inmates in the institution can have anger issues. So you don't think that this food fight with food flying all over the place wasn't dangerous or a serious issue?
Objection, Your Honor. Form of question. The portion of opposing counsel's question about the anger issues was actually stricken on redirect.
Response?
Your Honor, I'll withdraw that part of the question. So you don't think this food fight was dangerous or a serious issue?
No, absolutely not. Little kids have food fights in elementary school, and I honestly didn't see it to be an issue at all.
But Ms. Jones, you got injured during this food fight, so are you telling us that your injury is not a serious issue?
The only serious issue was when the guards came out of nowhere in a dying food fight and caused chaos and disruption. That is when my wrist was broken,
Ms.
so
Jones,
no.
I'm not asking about what the guards did. Are you saying that, well, even though you claimed this food fight was not a serious issue, your wrist was injured, so you're saying that this wasn't a serious issue?
My wrist was not injured in the food fight, so no, I don't believe it was.
Thank you. No further question, Your Honors.
You can step down. Thank you.
Thank you very much.
Ms. Cluse?
Yes, Your Honor. The plaintiff calls Dr. Jamie Lawrence to the stand.
Okay. You may proceed.
Thank you, Your Honor. Please state your name for the court.
My name is Dr. Jamie Lawrence.
What is your occupation?
I am a medical doctor, and I've been a licensed physician for the past 22 years.
Would you tell the court about your education?
Of course. I got my medical degree from Johns Hopkins University. I did my internship at the Barnes Hospital in St. Louis, and I completed my residency at the Buckeye University State Hospital.
So what is your medical training?
Well, during my residency, I did rotations in many different subjects, including oncology, internal medicine, pediatric medicine, radiology, and orthopedic surgery. I ended up doing numerous rotations in orthopedic surgery and radiology, and eventually became an orthopedic surgeon.
Now, what do you currently practice?
Well, like I said, I am now an orthopedic surgeon, and I work at the Orthopedic and Sports Medicine Center. However, I am also involved in some medical legal work.
What do you do as an orthopedic surgeon?
I work to diagnose and treat certain joint injuries, much like the wrist injury in today's case. However, I do also like to use radiology in my practice.
Why do you like to use radiology in your practice?
I like to analyze all of the MRIs, CT scans, and x-rays myself.
Now, earlier you mentioned medical legal work. What does that involve?
Well, about 10 years ago, I got involved in medical legal work, and I provide expert testimony regarding certain orthopedic surgery issues, where I'll either agree with or disagree with certain treatment procedures offered by other medical professionals.
Are you being compensated for your time today?
Yes, I charge my typical rate of $1,000 an hour, which covers my deposition and my trial time, and my travel expenses are paid as well.
Your Honor, at this time, I move to establish Dr. Lawrence as an expert in orthopedics, as well as radiology as it pertains to orthopedics.
I have no objections to Dr. Lawrence being found an expert in orthopedics. However, I do have an objection to Dr. Lawrence being found an expert in orthopedics with radiology. Pursuant to Rule 702, testimony by experts, Dr. Lawrence needs an educational background in radiology as well as a technical method. Dr. Lawrence's technical method of radiology is that he likes to use radiology. However, he is not a licensed radiologist, and he's not licensed to practice as a radiologist, and therefore should not be allowed to testify as a radiologist.
Your Honor, may I respond?
Yes.
According to Rule 702, I must show one of 5 things for him to be deemed an expert. I must show that he has specialized skill, training, knowledge, education, or experience beyond that of a normal person. He has testified to having numerous rotations in radiology in medical school, which goes to his education, skill, and training. He currently does use radiology in his practice, which also goes to his experience. Additionally, I believe opposing counsel referred to Rule 702, Part 2, and my witness's testimony will be based off of technical information, as he will be using an X-ray and records obtained from BJCI.
Your Honor, if I may respond, what Dr. Lawrence did not mention as part of his technical method is that he has to confirm every diagnosis he makes or every interpretation he makes of these radiological studies with a licensed radiologist. However, in court today, there is no licensed radiologist to confirm any of Dr. Lawrence's suspicions, and therefore he should not be found as an expert in radiology.
Your Honor, may I respond?
Yes.
Opposing counsel has taken out of the statement that he does confirm his diagnoses with radiologists. Also in the statement is that he has never once been wrong in an interpretation and only confirms with the radiologist to check that his interpretation is correct.
He'll be recognized as an expert in orthopedics, but not in radiology.
Yes, Your Honor.
Thank you, Your
Honor. Dr. Lawrence, how are you involved in today's case?
Ms. Jones was referred to the Orthopedic and Sports Medicine Center, and I was the physician that treated her and gave her an initial examination.
What did you learn at this initial examination?
Well, Ms. Jones told me that she sprained her wrist during a fight at BJCI, but then 3 weeks later when she saw me, she still had some pain and limited range of motion.
So what did you do?
Well, after reviewing the X-ray I was sent from BJCI and determining that the anomaly I saw on the X-ray could be indicative of a scaphoid fracture, I ordered an MRI.
You ordered this MRI even after reviewing the X-ray?
Yes, of course.
Why?
Well, injuries of the wrist are especially difficult to diagnose due to the complex ligament and bone structure of the wrist. However, I believe it's important not to rely solely on plain film X-rays, but to supplement them with other data.
What kind of other data?
Well, oftentimes, X-rays from the injured joints are compared with X-rays from the non-injured joints. But more importantly, information you can learn from the patient, such as the information Ms. Jones told me when she said she had pain and limited range of motion, is very useful in determining whether or not follow-up is necessary.
So, did the MRI help your diagnosis?
Yes, of course.
How so?
I was able to determine that Ms. Jones actually had a scaphoid fracture, not a sprain.
Now let's talk more about the medical care from BJCI. Did you review anything in preparation for your testimony today?
Yes, I was sent and reviewed all of the medical records, including the X-ray from BJCI.
Now, what did you learn from these records?
Well, I learned that the X-ray that the nurse took was very blurry and ultimately inconclusive. But like I said, there is an anomaly that could be indicative of a scaphoid fracture. In the records, it also said that the nurse noticed this anomaly, but still said the X-ray itself rules out a fracture.
Would you recognize a copy of the X-ray if I were to show it to you?
Yes, of course.
Let the record reflect I'm showing opposing counsel a clean and unmarked copy of Exhibit A. May I approach the witness?
You may.
What is Exhibit A?
This is a copy of the X-ray the nurse took of Ms. Jones' left wrist.
Now, based on your knowledge in orthopedics, what did you gather from this X-ray?
Well, like I mentioned, there is an anomaly which could be seen that could be indicative of a scaphoid fracture, which is located right there. But because of how blurry this X-ray is, to give you more of a visual, it would be located about right there on the wrist.
Now, according to the records you received, did the nurse do any follow-up to this X-ray?
No, she did no follow-up.
Do you have an expert opinion within a reasonable degree of medical certainty as to whether the nurse's diagnosis was proper?
Yes, I do.
What is that opinion?
The nurse's diagnosis was completely improper. A fracture could have been inferred, and in fact, the risk should have been obvious. Ms. Jones had complaints of pain and limited range of motion, and there's also an anomaly seen on the X-ray that the nurse took. Both of these things could be indicative of a scaphoid fracture, yet there was still a note from the nurse that said the X-ray itself rules out a fracture. More needed to be done to ensure Ms. Jones a proper diagnosis.
According to the records, what did the nurse do for treatment?
Well, the first time that Ms. Jones saw the nurse, she actually did nothing for treatment. But when Ms. Jones returned, she treated the injury with ice, tape, and rest.
Do you have an expert opinion within a reasonable degree of medical certainty as to whether the nurse committed any omissions in her treatment of Ms. Jones?
Yes, I do.
What is that opinion?
I believe the nurse committed many omissions because her treatment was insufficient and improper.
How was her treatment insufficient and improper?
Well, it was insufficient because, according to the records, Ms. Jones wasn't referred to a doctor or a specialist at BJCI at all. She was only seen by this nurse. And, it was improper because for the injury that Ms. Jones actually sustained, ice tape and rest just simply is not enough. An injury like Ms. Jones actually suffered needs to be mechanically immobilized as soon as possible, or there can be consequences.
Now, how could Ms. Jones be affected by this improper treatment?
Objection, Your Honor. This question calls for an answer into the damages portion of today's case, but we're here about the liability.
Your Honor, may I respond?
Yes.
The acts or omissions of the nurse in combination with the lasting injury because of them is relevant according to Farmer versus Brennan.
Your Honor, if I may respond.
Sure.
What could happen with the injury and what effect the injury could have goes to the damages portion, and it is relevant in the damages portion, but not in the liability portion of today.
Your Honor, may I respond?
One more time, that's fine.
The fact that the nurse committed omissions in her treatment, which have led to an injury, goes to the nurse's deliberate indifference under the ruling in Farmer versus Brennan.
I'm going to overrule the objection.
Thank you, Your Honor. Would you like me to ask the question again?
Yes, please.
How could Ms. Jones be affected by this improper treatment?
Well, Ms. Jones is never going to be able to achieve full recovery, but along with that, she's also at an increased risk for avascular necrosis and even arthritis in the future.
What is avascular necrosis?
Avascular necrosis is the death of bone cells due to a lack of blood supply to a certain area, and in this case, Ms. Jones' left wrist.
Why is Ms. Jones's risk increased?
Well, there are 3 weeks in which the displacement in Ms. Jones' left wrist had time to worsen, thus reducing the blood flow to her left wrist.
Now, you said that there were 3 weeks between the injury and your diagnosis. What makes you believe that?
Well, in determining exactly when this injury occurred, I looked at 3 main things. The first thing I looked at was the x-ray that was taken at BJCI, and the fact that there is an anomaly on there that could be indicative of a scaphoid fracture, and this and this x-ray was taken after the food fight at BJCI. The second thing I looked at was the fact that according to the nurse's records, Ms. Jones had complaints of pain and limited range of motion directly after the food fight at BJCI. The third thing I looked at was the fact that Ms. Jones did not identify a single incident where she could have hurt her wrist besides the food fight at BJCI when I interviewed her. And then because of these 3 things, I can determine that the injury happened while Ms. Jones was at BJCI and during the food fight.
Dr. Lawrence, how did you treat the injury?
I performed a surgery to mechanically immobilize the bone and prevent any further malunion.
Do you have an expert opinion within a reasonable degree of medical certainty as to the success of that surgery?
Yes, I do.
What is that opinion?
The surgery was as successful as it could have been.
What do you mean by that?
Well, like I mentioned earlier, Ms. Jones is never going to be able to achieve full recovery, but the maximum amount of recovery that is possible for her to achieve has been.
Why will Ms. Jones never be able to achieve full recovery?
Well, in my professional opinion, the significant delay in properly diagnosing this injury caused Ms. Jones the injury that she now has. A prompt diagnosis and proper treatment would have led to a full recovery, and Ms. Jones would no longer be at risk for avascular necrosis and even arthritis in the future.
Thank you. No further questions, Your Honor.
Mr. Gruber, cross-examination.
Yes, Your Honor. Your Honor, may I proceed?
You may.
Dr. Lawrence, you're a licensed orthopedic surgeon, correct?
That is correct, yes.
But you're not a licensed radiologist, isn't that true?
I rotated numerous times through my residency, but eventually I did decide to be an orthopedic surgeon, that's correct.
So you are not a licensed radiologist, is that true, Dr. Lawrence?
I mean, I've never been wrong in any of my interpretations.
Dr. Lawrence, you're not a licensed radiologist, yes or no?
Your Honor, my witness is entitled to a full response.
Your Honor.
He needs to respond to the question then.
Yes, Your Honor.
You can respond.
I've never been wrong in any of my interpretations, but no, I do not have a license in radiology.
Your Honor, could you please instruct the witness to answer my question with a yes or a no?
I think he did at the end. The first portion of the answer is stricken.
Thank you, Your Honor. And you have been in the field of medical legal work for 10 years now, correct?
Roughly 10 years, that's correct.
So you're a plaintiff's doctor, right?
I mean, I've testified for both the plaintiff and defense.
But you've testified for the plaintiff about 90% of the time, isn't that right?
The plaintiff is usually the side that takes issue with something, so yes, of course.
And you've worked with opposing counsel on multiple occasions, correct?
I have, yes.
And you're being paid $1,000 an hour for your testimony here today?
That's correct, yes.
And you examined Emerson Jones, correct?
3 weeks after she suffered her injury, that's correct.
So yes, you performed an examination?
Yes.
And in this initial examination with Ms. Jones, isn't it true that she told you she was not exactly sure how her injury occurred?
She said that she thinks that she was knocked down during a fight at BJCI, but she didn't know for sure. That's correct.
So that's a yes. She was not exactly sure how her injury occurred?
She wasn't exactly sure, no.
And she told you she thought her injury occurred when she was knocked to the floor. Is that what you're saying?
Yes, that's correct.
And in this initial examination, Emerson never made any mention of a guard Mendez, did she?
No, she did not. No, she did not.
She never made mention of a guard Burgundy. Is that right?
No, she didn't.
And so in your initial examination with Emerson, she never mentioned guards as the cause of her injury? Any guards?
Objection, Your Honor. Relevancy. This does not go to the witness's opinion at all. The fact that she did not elaborate on specifically what guard knocked her to the ground is not relevant to his testimony.
Your Honor, if I may respond, I'm not going to Dr. Lawrence's opinion. I'm asking Dr. Lawrence what Ms. Jones told Dr. Lawrence as the cause of her injury, and that without a doubt goes to the liability portion of today's proceedings.
Your Honor, may I respond?
Sure.
Again, the specific names of the guards is not relevant. The fact that she did not specifically name the guards does not go to his opinion in today's case or the credibility of Emerson Jones, because stating names is not necessarily relevant to his testimony.
This is cross-examination. Objection will be overruled.
Yes, Your Honor.
Would you like me to repeat the question?
Yes, please.
So isn't it true that in your initial examination with Emerson, she never mentioned any guards as the cause of her injury?
The only thing she said is that she thinks she was knocked down, so no.
So she never mentioned any guards?
No, she did not.
And you ordered an MRI of Ms. Jones's wrist, correct?
Yes, that's correct.
And then you performed surgery on this wrist?
Of course, yes.
And you restored Emerson to a level of maximum recovery, correct?
As much as which was possible, that's correct.
And you restored her pain issues, correct?
Again, as much as possible, that's correct.
Isn't it true that you resolved her range of motion sufficiently?
Again, as much as possible, yes.
And you reviewed Nurse Rogers' medical records of Emerson, correct?
Yes, I did.
And do you have Exhibit B up there with you?
Exhibit B, no.
Your Honor, at this time, I request permission to approach the witness for purposes of examining Exhibit B.
You may do so.
May the record reflect I'm showing opposing counsel a clean and unmarked copy. Dr. Lawrence, do you recognize Exhibit B?
Yes, this is the nurse's notes from BJCI.
And based upon Exhibit B, isn't it true that Nurse Rogers ordered an X-ray of Ms. Jones's wrist?
A very blurry X-ray that was ultimately inconclusive,
Dr.
yes.
Lawrence, I didn't ask you whether the X-ray was inconclusive or whether it was blurry. I asked you, did Nurse Rogers order an X-ray?
She did, yes.
And she noted an anomaly in this X-ray, correct?
Yes, that's correct.
And then she performed a physical examination of Ms. Jones's wrist, correct?
That's what it says in the medical records, that's correct.
And based upon these medical records, isn't it true that Nurse Rogers diagnosed Ms. Jones's injury with a sprained wrist?
That's what it says in the medical records, that's correct.
And then for that diagnosis, Nurse Rogers gave Emerson a treatment plan of ice, tape, and rest, correct?
Recommended rest, that's correct, yes.
She also gave Emerson a sling for immobilization?
According to the records, yes.
Based upon these records, Nurse Rogers told Emerson to consult with her primary care physician after her release from BJCI. Isn't that true?
Exactly. She wasn't referred to a physician at the facility.
I didn't ask you if...
Objection, Your Honor. Again, my witness is entitled to a full opinion. He had not even finished his answer when opposing counsel assumed he wasn't answering the question.
I wasn't assuming that he wasn't answering the question. He added in the part about Nurse Rogers didn't tell her this, and I didn't inquire into that.
That portion of the answer will be ordered stricken.
Thank you, Your Honor. So I'll ask you the question again. Isn't it true that Nurse Rogers told Emerson to consult with a primary care physician upon her release?
Only after she got out, yes.
And there was about a 2-week time period after Emerson was released from BJCI, correct?
Yes, that's correct.
And Emerson waited this entire 2-week time period before she came to your office, correct?
Before to me specifically, yes.
And Emerson was referred to your office by her lawyer. Isn't that right?
Yes, that's correct.
So Emerson had a consultation with her lawyer before she ever had a consultation with you. Is that right?
Yes, that's correct.
And there's no conclusive evidence to suggest that Emerson broke her wrist while at BJCI. Isn't that right?
All of the evidence that I have supports the fact that she injured her wrist at BJCI.
But there is no conclusive evidence to say that Emerson broke her wrist while at BJCI. You have your assumptions, Dr. Lawrence, but you knew that Emerson broke her wrist after you took an MRI in your office. Isn't that right?
Yes, that's correct.
And you weren't at BJCI, were you?
No, I was not.
So you weren't there for the injury?
No, I was not.
You weren't there for the examination, is that right?
I have all the nurse's records, but no, I was not.
And you don't know what Emerson did during those 2 weeks, do you?
All I know is that she didn't tell me anything that could have hurt her wrist, but no.
You don't know if Emerson played basketball during this 2-week time period?
Well, playing basketball certainly wouldn't cause a fracture, but no, I don't know.
And you don't know if Emerson played tennis during this 2-week time period, do you?
No, I do not.
So with all due respect, Doctor, you have no idea what Emerson could or could not have done to her wrist during that 2-week time period between her release from BJCI and her visit in your office.
All I know is that she didn't tell me anything that could have hurt her wrist, so no.
And isn't it true, Dr. Lawrence, that the only thing we do know is that when Emerson did come to your office 2 weeks later, her wrist was, in fact, broken, correct?
Yes, that's correct.
Thank you, Your Honor. No further questions.
Redirect. Your Honor.
Dr. Lawrence, did Emerson Jones, after your surgery, achieve full or maximum recovery?
Maximum recovery. She's never going to be able to make a full recovery.
Now, based upon the medical records that you received from BJCI, did the nurse do any follow-up to the x-ray?
No, she did no follow-up at all.
Now, did Emerson Jones see a physician at the institution?
At the institution itself, no. She was never referred to a doctor or a specialist while she was there.
Do you know if Emerson Jones went to see another doctor before coming to you after her release?
I have no idea. No, she could have gone to any other doctor before coming to me.
Why do you believe that the fracture occurred at BJCI?
Well, I have all of the information that I mentioned during direct, with the x-ray, with her complaints of pain and limited range of motion, and with all of the, and with the fact that she didn't identify a single incident where she could have hurt her wrist.
Now, was the anomaly that appeared on the x-ray noticed by the nurse?
She noticed it, but then still said the x-ray itself rules out a fracture, yes.
And finally, would you briefly elaborate on your education and experience with regard to radiology?
Objection, Your Honor. The court has already found Dr. Lawrence is not an expert in radiology, and testifying to his expertise is irrelevant.
Your Honor, may I respond?
Yes.
I'm not trying to sustain him as an expert, but opposing counsel on cross did attack the witness's credibility regarding his radiology, and I'm just merely exploring that testimony.
I'm going to sustain the objection.
Thank you, Your Honor.
Dr. Lawrence, were you able to reach a conclusion about the injury without knowing the specific names of the guards?
Yes, I was.
What was that conclusion?
That the injury happened while she was at BJCI, and it happened during this food fight.
What was Ms. Jones's injury?
It was a broken wrist of
Thank
the
you.
scaphoid bone.
Thank you. No further questions.
Recross.
Yes, Your Honor. Your Honor, may I proceed?
You may.
Dr. Lawrence, you had an initial examination with Emerson, correct?
I did, yes.
And you believe everything Emerson told you in this examination to be true, correct?
Yes, that's correct.
So when Emerson told you that she was not exactly sure how her injury occurred, you believe this to be true, isn't that right?
I believe that she herself did not know exactly how the injury occurred, yes.
Thank you, Your Honor. No further questions.
Okay. You may step down. Thank you. Does the plaintiff rest at this time?
The plaintiff rests, Your Honor.
Okay. Mr. Gruber, you may call your first witness.
Yes, Your Honor. The defense would like to call Ms. Casey Burgundy to the stand. Your Honor, may I proceed?
You may.
Please state your name for the court.
Casey Burgundy.
What is your occupation?
I'm a senior guard at the Buckeye Juvenile Correctional Institute.
What is your educational background?
I graduated from the University of Cincinnati with my Bachelor of Science degree in Criminal Justice.
What is your experience in your profession?
I started working part-time at BJCI when I was in college. I worked there as a receptionist and assisted the family members who were there to visit the inmates. When I graduated from Cincinnati, I was hired as a full-time juvenile detention officer. And 4 years later, in January of 2013, I was promoted to my current rank of senior guard.
And how do you approach your work at BJCI?
Well, first and foremost, I'm a guard. Most important things to me are the order of the facility and the safety of the inmates. I also try my best to impart some wisdom along the way. Let these kids know they don't have to let their time at BJCI define them.
Your Honor, at this time, I request permission to approach the witness for purposes of examining Exhibit C.
You may do so.
May the record reflect I'm showing opposing counsel a clean and unmarked copy. Ms. Burgundy, could you identify Exhibit C for the court, please?
Yeah, this is a map of BJCI.
And how does BJCI operate on a day-to-day basis?
Well, we have 3 blocks. There's Block A, Block B, and Block C. Each block has 2 sets of bed and restroom areas, one for male, another for female. The blocks take their recreation and meal times separately, and within the same block, the meal and recreation is taken at the same time with male and female inmates.
And to which cell block are you currently assigned?
I'm assigned to Block C, where Emerson Jones was placed.
How are inmates assigned to their cell blocks at BJCI?
It's mostly random.
Who is Emerson Jones?
Jones was an inmate serving a 4-year sentence for aggravated robbery.
And how, if at all, did you interact with Ms. Jones?
Jones always talked about basketball, seemed pretty talented, and was always playing during rec time. She actually had told me that OSU offered her a scholarship to play there, but when she was arrested, they withdrew. She still planned to pursue basketball after her release.
And how did you respond to Ms. Jones when she would talk to you about basketball?
I encouraged her not to worry too much about sports, to focus more on getting an education and finding a career path instead.
How did Ms. Jones respond to you?
She didn't really respond. She began to hang with what she called her family.
What is a family?
A family is a gang.
Were some of the gangs at BJCI?
We had the Big Macs and the veggies. The Big Macs wanted cheeseburgers, veggies wanted vegetables. They started causing a lot of problems at the facility.
What kind of problems did they cause?
It began when there was this altercation in the common room between the families. It was just a verbal fight, no blows were exchanged, but it's still very serious.
Well, why was this altercation serious if there were no blows exchanged between the families?
These situations can escalate quickly in a matter of seconds into a brawl. And it also indicates to the other inmates that this disorder and chaos is just a part of their life. The biggest concern from our point of view is that we lose control.
To your knowledge, was Emerson Jones involved in this incident?
Yes, she was.
Why do you believe this?
You see, Jones is just one of those inmates who treats the whole thing as a game. Doesn't really believe in any particular cause, but just wants to watch everybody lose it. From that point on, I knew I had to keep an eye on her.
Objection, Your Honor. I would like to strike the portion of the witness's testimony where she said that Jones just wants to see everybody lose it and doesn't believe in any of that as speculation.
Your Honor, may I respond?
Yes.
Pursuant to Rule 701, Ms. Burgundy is offering her layperson's opinion of Ms. Jones based upon her rationally based perceptions of observing the plaintiff for 4 years at BJCI.
May I respond, Your Honor?
Yes.
Pursuant to Rule 602, she can't give that testimony because she was testifying to Emerson Jones' mindset, which she can't possibly know.
Objection is sustained as to the particular portion of the testimony you're objecting to.
Ms. Burgundy, were there any other conflicts between the two families after the altercation in the common room?
There was.
What happened?
About 2 months after the initial fight, further than a verbal fight, a physical fight broke out between the families. It began as a food fight, but quickly escalated to a riot. Numerous members from both families were going at it.
Objection, Your Honor. Move to strike the portion of the witness's answer where she called the food fight a riot as an invention of facts.
Your Honor, Ms. Burgundy is not inventing the facts. She was present at the riot. She was involved with the riot, and she would certainly have an idea of what this riot was like.
May I respond, Your Honor?
Yes.
It's my understanding that the statement actually indicates that it was stopped before it became a riot. Of course, the opposing counsel can point to a line number that indicates that it was a riot. That would be sufficient.
Objection will be sustained only as to her characterization of the incident as a riot. You may proceed.
Thank you, Your Honor. Without calling the altercation a riot, what happened in the cafeteria?
Like I said, it started as a food fight, but then the families got crazy. It was complete chaos, and they were just going at it.
Were you present for this fight?
I was.
What did you do?
In order to prevent the situation from escalating any further, I ordered all inmates to the ground against the cafeteria walls, as was our protocol.
What protocol do the guards at BJCI have for situations such as the altercation in the cafeteria?
We have rules in the Ohio Administrative Code, and we received a memorandum from Jared Ritz at the Ohio Youth Services Correctional Facilities.
Your Honor, at this time, I request permission to approach the witness for purposes of examining Exhibit D.
You may do so.
And the record reflect I'm showing opposing counsel a clean and unmarked copy. Ms. Burgundy, could you identify Exhibit D for the court, please?
This is the memorandum I was referring to, and it's regarding the use of less than deadly force.
And where in this memorandum are guidelines that would apply to the situation in the cafeteria?
Section 4 policy basically just outlines that the correctional guards are allowed to use force when we are responding to resistance, protecting our inmates, and to enforce our rules.
Based upon these guidelines, could you explain the difference between the use of force and the use of force during this altercation?
In procedures, it outlines that the situations that require force arise very quickly, and it's at the discretion of the guards to use only the amount of force necessary to control the situation.
Based upon these guidelines, how are the guards supposed to determine when to use force?
We use force when an inmate's not obeying our rules, regulations, or orders, or if they are engaged in a riot or other disturbance.
So let's return to this fight in the cafeteria. After you gave your order, what happened next?
Well, one inmate in particular, Emerson Jones. She didn't just sit on the sidelines during this fight, but she was one of the first inmates involved, and she completely disregarded my order.
What happened when Ms. Jones disregarded your order?
Well, another guard, George Mendez, gave the command specifically to Jones, get down and against the cafeteria walls. Jones then reached for a saucer of ketchup, and in order to prevent Jones from throwing the projectile, Jones was taken to the floor.
Objection, Your Honor. Move to strike the portion of the witness's answer where she referred to a command by Guard Mendez to Emerson Jones to get on the ground as hearsay.
Your Honor, if I may respond, in direct examination of Emerson Jones, the statements of Guard Mendez were allowed in based upon Guard Mendez being a party opponent of BJCI, and that principle would apply here.
May I respond, Your Honor?
Yes.
Those statements were admissions by party opponents. This statement is certainly is not.
The objection is going to be overruled, not on the basis that you're stating, but it's not being introduced for the truth of the matter asserted. So I'm going to overrule the objection.
Thank you, Your Honor. Ms. Burgundy, did you finish your answer?
I did.
And after Guard Mendez, strike that, Your Honor. What was the atmosphere in the cafeteria after Ms. Jones was taken to the ground?
Finally, order had been restored. It was becoming a calm environment.
And what did you do after the altercation was finished?
I asked the inmates if any of them needed new clothing or medical attention. The ones that indicated they did were then taken to those areas.
And was the plaintiff among these inmates?
Of course, in our memorandum, there's a section that tells us any inmate involved in the use of force needs to be taken to the infirmary.
Were you with the inmates when they went to the infirmary?
Yes, I took them there.
And to your knowledge, what happened at the infirmary?
The nurses met with the inmates with more minor injuries. Anything more serious was referred to the physician.
What happened, to your knowledge, with the plaintiff at this time?
She met with a nurse and then returned back to the cell block.
And in the subsequent days, what contact did you have with the plaintiff, if any?
Jones kept complaining that her wrist hurt.
What did you do about these complaints?
Well, eventually, I relented and took Jones to the infirmary on 3 separate occasions.
Why do you say that you eventually relented to take the plaintiff to the infirmary?
Well, she was nearing the end of her sentence, and I told her to tough it out because I saw her playing basketball during rec time. I didn't think a wrist injury could be that bad if she still wanted to play.
Are you aware?
Objection, Your Honor. Move to strike the portion of the witness's answer where she characterized the seriousness of Ms. Jones' injury as an improper expert opinion.
Ms. Burgundy was not offering her expert opinion in any way. She was offering her layperson's opinion of what she perceived of the situation of Ms. Jones playing basketball.
May I respond, Your Honor?
Yes.
It is an expert opinion. To be able to say that an injury is serious or not requires medical expertise.
Objection is sustained.
And are you aware of the diagnosis of Ms. Jones' injury at BJCI?
I am.
What was it?
Jones had a sprained wrist.
Thank you, Your Honor. No further questions.
Cross-examination.
Yes, Your Honor. Now, Ms. Burgundy, you and the other guards try to split up inmates when it seems like they might be involved in gang activity. Isn't that right?
That is the policy. We're not always able to put it into action, but that's the basic policy.
Right, so it is a policy that you try to follow, correct?
I did say that, yes.
Now, it was clear to you that the Big Macs and the Veggies were rivals, wasn't it?
Yes, it became clear when they started fighting each other.
Well, in fact, you believed that they were involved in gang activity, correct?
Could you say that question again? It didn't make
Now,
sense.
you believed that the Big Macs and the Veggies were gangs, right?
Yes,
And they were involved in several altercations, weren't they?
I did explain that, yes.
Now, they got into a shouting match, correct?
Yes,
Now, you thought that was a big deal, didn't you?
it is a big deal.
Right, and things like that in a prison can be serious business, correct?
Absolutely.
They can be dangerous, can't they?
They can be. Luckily, we were able to control the situation before it ever got to that point.
Right, and there were 2 months between that shouting match and the food fight, correct?
Yes, all fighting had subsided for that time.
Well, in those 2 interim months, you didn't try to split the groups up, did you?
Like I said, all fighting had subsided. We had no reason.
They did have an altercation, though, correct?
And we controlled it, and then nothing happened for 2 months. We figured that we had controlled it enough.
Now, after those 2 months, a food fight broke out between the groups, correct?
Yes.
After that food fight, injured inmates were taken to the infirmary, right?
Where else would we take injured inmates?
So that's a yes.
Yes.
Now, I'd like you to refer back to the memorandum that you used on direct for me. Could you look at the 3rd page of that document, the portion labeled C, Medical Assistance? Do you see that?
Yeah.
I'd like you to follow along silently as I read that aloud. Immediately following a use of force, medical attention shall be provided, even when the inmate does not appear to be injured. Did I read that correctly?
You did.
So according to the memorandum that you use, all inmates on whom force was used have to be taken to the infirmary, even if they don't seem injured, right?
Yes, that's what happened with Miss Jones.
Well, actually, all that you know is that all of the injured inmates were taken, correct?
No, I know that we took Jones to the infirmary, and she was in the use of force. That's why we took her.
Right, Jones was taken, but you only took the injured inmates, right?
Jones went to the infirmary. We didn't take 2 separate trips.
Well, I don't think you understood my question. I wasn't asking you about Miss Jones. I was asking, you took the injured inmates to the infirmary, right?
In addition to the inmates involved in the use of force, they were all taken to the infirmary.
Well, actually, you didn't say in your statement that you took any inmates other than the ones who were injured to the infirmary, did you?
Objection, Your Honor. I feel like this question has been asked and answered a couple times already.
May I respond, Your Honor?
Yes.
The witness hasn't clearly answered my question. I'm clarifying her testimony.
Objection is overruled. You can ask the question again.
So you didn't say in your statement that you took any inmates other than the ones who were injured to the infirmary, did you?
Did you say that I didn't say that?
Correct. You did not say that in your statement, did you?
Ask it again. That's very confusing.
In your statement, you only said that the injured inmates were taken to the infirmary, correct?
Yes.
So you don't know if there were any inmates on whom force was used who were not taken, do you?
Objection, Your Honor. This question calls for my witness to speculate. She testified that she took the injured inmates to the infirmary. That's all she knows.
May I respond, Your Honor?
Yes.
That's exactly what I'm showing. I'm showing that she doesn't know.
Objection is overruled.
Thank you, Your Honor.
Would you like me to repeat my question?
I would.
So you don't know if there were any inmates on whom force was used who were not taken to the infirmary, do you?
I can infer based upon our policy because we follow our policies.
But you don't know if the other guards followed your policy in this case, do you?
I am not the other guards.
Now, Emerson Jones, as you said, was among the inmates that were taken to the infirmary, right?
Yes.
Now, you didn't accompany her into the infirmary, did you?
I took the inmates there, but I was not in their meetings, no.
Right, so you don't know what Emerson Jones' treatment was, do you?
No.
Now, all that you know is that she returned shortly to her block, correct?
Yes.
Over the next 3 days, as you said on direct, she complained to you about her wrist hurting, didn't she?
Yeah, Jones kept complaining, yes.
And for 3 days, you just told her to tough it out, didn't you?
I did tell Jones to tough it out, you're right.
Now, when you finally did relent, like you said on direct, and take her back to the infirmary, you found out she had a sprain, right?
Yes, that's what the nurse told me.
I'd like to explore Emerson's injury. Could you refer back to the memorandum for me one more time?
Sure thing.
I'd like you to look at the second, or the portion of that document on the second page labeled 5A, the use of force generally. Do you see that?
I do.
Now, I think you used that on direct, and that portion of the memorandum outlines when guards are allowed to use less than deadly force, right?
The whole thing is about less than deadly force.
Well, these 4 points below use of force generally, those are the instances in which guards are allowed to use less than deadly force, right?
Yes, you are correct.
Now, Ms. Burgundy, you weren't physically attacked by an inmate, were you?
No, I do not let inmates attack me.
Okay, well, neither were any other guards or inmates as far as you know, were they?
Guards or inmates? The inmates were fighting with each other.
Well, actually, all that you included in your statement was that they threw some French fries at each other, right?
Objection, Your Honor. This is an improper use of the deposition. If opposing counsel would like to impeach or refresh my witness, that's fine. Or if he would like to provide a line number for the court, that is also admissible.
May I respond, Your Honor?
Yes.
This wasn't an improper use of the statement, but if you would prefer, I could rephrase my question.
Objection's overruled.
Thank you, Your Honor.
So according to your deposition, the inmates were only throwing French fries at each other, right?
Yes, the French fries were thrown in the food fight, yes.
Now, I believe that on direct you said you gave an order for Emerson Jones to get on the ground, right?
I gave an order for all of the inmates.
Oh, that's right. It was to all the inmates, correct?
Yes.
Now, you don't know if Emerson Jones heard that order, do you?
I'm not Jones. You probably should have asked her.
So that's a no.
It's a no.
Emerson Jones didn't destroy any property, did she?
Everything was getting pretty dirty because of the food fight, so I'd say that was a problem to our property, yes.
Okay, so she may have gotten some French fries on the floor and a couple tables, right?
It's much more than that, Counselor.
You didn't include any more than that in your deposition, did you?
I can tell you that it was more than that based upon the fact that it was a food fight.
But that's a no to my question. You didn't include any more than that in your deposition.
Objection,
right?
Your Honor. My witness is allowed to make reasonable inferences based upon the relevant omissions in her deposition, so she's not entirely tied to this deposition when opposing counsel is cross-examining her on these relevant omissions.
May I respond, Your Honor?
Yes, you may.
I agree that the witness is allowed to reasonably extrapolate, but on the same token, I am allowed to rein in that testimony using her deposition.
Objection. It is a reasonable elaboration.
Yes, Your Honor.
Okay.
Now, Ms. Jones wasn't participating in a riot, was she?
I would call it a riot.
Well, actually, in your deposition, you said that you stopped it before it became a riot, right?
My reasonable extrapolation is that these inmates were trying to incite a riot.
To be clear, you didn't include that it was a riot in your deposition, did you?
No, I did not say that word.
Now, as far as you know, Emerson Jones certainly wasn't trying to escape, was she?
No.
I'd like to explore your relationship with Miss Jones. You don't like her, do you?
I wouldn't say that.
Okay, let's look at that. You would agree there was someone leaving notes in the library aiming to rile up the Big Macs and the veggies, right?
Yes.
You thought that that was Emerson Jones, didn't you?
I thought, but I couldn't conclusively determine who left the notes. I wouldn't blame Jones because I don't know.
That was your opinion, though, correct?
I had my suspicions, yes.
And like you just said, you didn't really have any evidence for that opinion, did you?
That is what I said.
Now, you also thought that Emerson Jones started a verbal argument that followed the notes, right?
Yes.
The only evidence that you had of that is that she was standing calmly on the sidelines as it went down, right?
You are incorrect.
So you included other evidence of that?
Yes. Jones was whispering to members of both families. She was watching this altercation calmly. You shouldn't be calm when inmates in a correctional facility are screaming at each other. That's a very dangerous situation.
Oh, okay, so you also knew that she whispered to a couple other inmates before it broke out, right?
Yes.
But you didn't see Jones specifically participate in the argument, did you?
No.
Now, after the food fight that broke out, you interviewed inmates, right?
Yes.
You wanted to find out who started the food fight, correct?
Yes, of course we did.
None of them could tell you who started it, could they?
No, it was a very chaotic environment. I think all inmates were just thrown for a loop.
So that's a no.
That is a no.
Now, like you testified several times, you're aware that Emerson Jones has a sprain, right?
Yes.
And yet you believe that in today's case, she got what was coming to her, right?
No, Counselor, yes, I do.
Thank you, Your Honor. No further questions.
Redirect.
Yes, Your Honor. Your Honor, may I proceed?
You may.
Ms. Burgundy, what did you mean when you said the plaintiff got what was coming to her?
In a facility like the BJCI, you reap what you sow. Jones had the opportunity to better herself while she was in our institute, but instead she joined a gang. She got involved in altercations, and I'm sad that she got injured. I'm sad that she couldn't make the best of her time here, but that is Jones' fault.
Why wasn't the plaintiff separated from these families during her time at BJCI?
We had no conclusive evidence that Jones was responsible for these altercations at all. We didn't want to move an inmate if they were innocent.
Why was force used against the plaintiff?
Jones did not obey 2 orders, and Jones tried to reach for a saucer of ketchup to further engage in the disturbance. We couldn't allow that to happen.
Thank you, Your Honor. No further questions.
Any recross?
Yes, Your Honor. Now, Ms. Burgundy, you would agree with me that you do believe that Emerson Jones left those notes and started that argument, right?
Objection, Your Honor. This is outside the scope of my redirect. I didn't ask anything about the notes.
May I respond, Your Honor?
Yes.
Opposing counsel opened the door when he asked the witness why she didn't move Emerson Jones, and she said that she didn't have any conclusive evidence.
Objections overruled.
Thank you, Your Honor.
Would you like me to repeat my question?
I would.
So you believed that Emerson Jones left those notes and started the argument, right?
As I've told you before, I did have suspicions, but I don't know.
Now, as you admitted on redirect examination, you didn't have any conclusive evidence, did you?
As I admitted 1 question ago, I didn't have any conclusive evidence.
Now, you also didn't have any conclusive evidence that she was involved in the food fight, did you?
Yes, I do. I saw her.
Well, you think you saw her throw some fries, right?
Objection, Your Honor. Opposing counsel can't tell my witness what she thinks she saw.
Objection is sustained.
Thank you.
Ms. Burgundy, the only evidence that you have is that you saw Emerson Jones throw a couple French fries, right?
This is still regarding the food fight?
Yeah, regarding the food fight, you only know that you think you saw her throw a couple French fries, right?
Objection, Your Honor. I renew my...
I can rephrase, Your Honor.
Would you please do so?
Yes, Your Honor. So regarding the food fight, the only evidence you have is that Emerson Jones threw a couple French fries, right?
Yes, and Jones didn't obey orders and tried to further engage in the disturbance.
Now, you also admitted that you do believe that Emerson Jones got what was coming to her, right?
I've said that multiple times.
But on cross-examination, you said that you don't dislike Emerson Jones. Isn't that right?
Yes.
Thank you, Your Honor. No further questions.
You can step down. Thank you. Mr. Von Cotter-Romani, you may call your next witness.
Yes, Your Honor. The defense would like to call Ms. Blair Healy to the stand.
Okay.
May I proceed?
You may.
Please state your name for the court.
Blair Healy, Healy.
And how old are you?
I'm 18.
Are you in school right now?
I actually go to school at BJCI. I'm currently doing some time there.
Why are you doing some time there?
It's for an aggravated robbery.
Are you contesting that?
Yes, I am.
And why?
Well, I didn't commit that crime.
Why should this court believe that you didn't commit that crime?
I have an early release hearing coming up soon, in a few weeks, and they don't give those to people who are guilty.
Objection, Your Honor. I move to strike the portion of the witness's statement where she said that early release hearings are not given to people who aren't guilty as speculation.
Your Honor, my witness is not speculating. She has been in the juvenile system, and so she would have knowledge of how the system works.
Objection is sustained.
And to your knowledge, who's hearing that early release appeal?
Well, I was told that the Ohio Supreme Court is hearing that.
Did you know Miss Emerson Jones in BJCI?
Yes, I did.
What did you know of her?
Well, I knew that she was in a pretty tough gang.
And from your observations, can you describe this gang for the court?
They were intimidating and violent. They were always looking for excuses to hurt people and get what they wanted.
Objection, Your Honor. I move to strike the witness's answer as improper character evidence.
Your Honor, this goes to the truthfulness of the witness and what she has seen in BJCI to go to the conditions within. It's not improper.
Your Honor, may I respond?
You may.
Whatever violence the witness thinks that the gang was a part of and the intentions of the gang is certainly character evidence and does not in any way go to the truthfulness of Emerson Jones.
Objection is sustained.
Were you and Miss Jones, well, strike that. Was Miss Jones in your cell block?
Yes, cell block C.
So, to your knowledge, how did she act?
Well, as you saw, she always plays the victim, and she whined about everything, from the clothes and the rooms to the guards and the food. It's not like prison is easy.
Objection, Your Honor. I move to strike the first part of the witness's statement where she said that Emerson Jones always plays the victim as improper character evidence.
Your Honor, my witness is just giving her opinion based on her perception of Miss Jones and what she has seen of her in the institution.
Your Honor, may I respond?
Objection is sustained.
And you said that Miss Jones liked to whine about guards. Was there any guard in particular?
Well, yes.
Who was this?
Guard Mendez. She said that she was going to get Guard Mendez back for something that she supposedly did to her.
What kind of contact did you have with Jones before the altercation in the cafeteria?
Well, like I said, we were in the same cell block, but also we both entered this contest that was at the prison.
Without telling us what happened during that contest itself, can you tell us what happened as a result?
Well, she won, I lost. That's pretty much all there is to it. I got over it a long time ago, but Emerson constantly rubbed it in my face.
So are you here to testify for the fact that she constantly rubbed it in your face?
Of course not.
An important issue today is Jones's wrist injury. Do you know how that happened?
Yes.
Did you actually see it happen?
Yes.
When was this?
It was in the food fight that happened at BJCI in the cafeteria.
Now, you said you were present for this. Can you tell us what you saw?
Well, I saw Emerson start the whole thing. She was the first one to pick up food and throw it. Pretty soon, everyone followed what she was doing, and the whole room was just a mess. It was in chaos.
While the room was a mess and chaotic, what were you doing?
Well, I went to the wall and I sat down.
And why did you do that?
Well, I didn't want to get in trouble for something I didn't do, so of course, I went and got out of the way.
And did anyone else do that, to your knowledge?
Yes, everyone who wasn't participating went to the wall and sat down.
And from what you saw, did Jones do that?
No, she stayed in the center of the room. She was participating.
You said you were on the floor, so could you see the fight clearly?
I had a straight shot, and of course I was watching Emerson.
Now, what happened after the room became chaotic?
Well, pretty soon, a bunch of guards came running in, and they were screaming for everyone to get on the wall and on the floor. That's pretty much it.
Objection, Your Honor. I move to strike the witness's answer as an invention of facts. It does not say in her statement that when the guards rushed in, they said that to get on the ground.
You want to point to me where it is in the statement?
Your Honor, momentarily. Your Honor, in lines 456 to 457, Ms. Healy's deposition states, I heard Guard Mendez order Emerson to stop throwing food and get on the ground.
Your Honor, may I respond?
Yes.
The witness did not testify to this. She testified that when the guards first came in, they ordered for all of the inmates to get on the ground. In the previous line, it says that they came in, but not that they ever gave this order.
Your Honor, I'll withdraw that part of the question. Now, you said that the guards came in. What happened after they came in?
Well, Guard Mendez told Emerson to get on the ground and stop throwing food, as you just read. But Emerson didn't listen.
And what happened after that?
Well, Guard Mendez grabbed her and tried to take her to the ground, but she was struggling and she got away. So she started running after another guard.
What happened after she started running after the other guard?
Well, there was an inmate lying on the floor right in front of her, and as she was running, she tripped right over her and fell on her wrist.
What happened after she fell?
Well, she got up and she shook her wrist like it hurt for a couple of seconds, but then she started hitting and swinging again.
So, did the fight eventually end?
Yes, it did.
Did you see Jones anytime after the fight?
Yes.
And what was this?
Well, a few days later, she came in with a brace on her wrist, and she was telling everyone that she was going to get out of the institution because of the injury, and that she would sue them.
Did you have any further contact with Jones?
Yes.
And what was this?
Well, this time, she asked me to lie for her.
What was this lie about?
She wanted me to tell everyone that Guard Mendez was out to get her, and that this time, he hurt her on purpose.
Did you do what she asked you to?
Of course not. It was a lie.
And would you lie for Emerson Jones today?
No.
So, if what she asked you to do was a lie, what's the truth?
Well, the truth? That's exactly what I've told you here today. Emerson didn't listen to the orders. She fell, and she ended up hurting herself.
Objection, Your Honor. I move to strike the portion of the witness's statement where she said that Emerson Jones didn't listen to the order as speculation. She doesn't even know if Emerson heard the order.
Response?
Your Honor, she's not testifying to Emerson's mindset. She's testifying as to what she saw during the food fight. She said that she heard Guard Mendez make an order and that she saw Emerson not listen to it.
Your Honor, may I respond?
Well, the statement to the effect that Emerson Jones didn't listen will be sustained. That portion of the answer will be stricken.
Had you completed your answer?
Yes.
Thank you. No further questions, Your Honor.
A cross-examination?
Yes, Your Honor. May I proceed, Your Honor?
You may.
Now, Ms. Healy, as you said on direct, you were incarcerated for committing a robbery, right?
Yes.
Objection, Your Honor. This goes to prior bad acts.
Your Honor, may I respond?
Yes.
This was already brought up on direct testimony, and I'm not going this to necessarily prove her character or improper character evidence, as this is going to her truthfulness, as a dishonest act does show dishonesty.
If it was brought up earlier, why are you bringing it up again?
Your Honor, I'm laying foundation for further questioning.
Objection will be sustained.
Thank you, Your Honor.
This isn't your first time in BJCI, right?
Once again, Your Honor, objection. This still goes to prior bad acts.
Your Honor, may I respond?
Yes.
I'm laying foundation to go to the witness's propensity for truthfulness.
Sustained.
Thank you, Your Honor.
I'd like to talk about your relationship with Emerson Jones. You don't like her, right?
I wouldn't say we're best friends.
You agree that you actually have a personal issue with her, right?
I'm not sure what you're referring to.
So it's your testimony today that you do not have a personal issue with Emerson Jones?
I didn't say that. I'm just asking you what you think my personal issue is.
Well, you and Emerson were finalists at a competition at BJCI last year, as you testified on direct, right?
That did happen, yes.
And the winner got a free week of commissary, right?
Yes.
And this was a big deal to you, wasn't it?
Commissary is a pretty great thing.
Emerson won, didn't she?
Yes, she did.
And you think that she won because she sucked up to the judges, right?
Well, based on everything I've seen with her, that was a pretty accurate assumption.
And you think that she's a jerk, right?
Because she always bragged about it, not because she won.
Well, so again, you agree that you have a personal issue with her, right?
If that was the personal issue you're referring to, then yes.
Now, I'd like to talk to you about the food fight that happened at BJCI. You witnessed the food fight, right?
Yes.
But you agree that much of C Block actually stayed out of the fight, right?
Yeah, we were all pretty much against the wall.
But according to you, many of the guards rushed in to stop the food fight, correct?
Yes, they did.
And you saw Guard Mendez grab Emerson, right?
Yes.
You saw Guard Mendez grab Emerson by her arms and attempt to pull her down, right?
Attempt, yes.
Well, right, and then Emerson got away from Guard Mendez, correct?
Yes, that would be an attempt and a failure.
So that's a yes.
Yes.
And then you think that you saw her trip and fall over an inmate, right?
Objection, Your Honor. Opposing counsel cannot tell my witness what she thought she saw.
Your Honor, may I respond?
Yes.
I'm only asking the witness to agree that she said this in her statement and it is her belief. If she does not think this, she is welcome to say so.
The form of the question, the objection is sustained.
Yes, Your Honor. Emerson fell over an inmate, right?
Tripped and fell because she wasn't listening to orders.
So you think, so Emerson wasn't listening to orders, right?
Well, apparently I'm not allowed to say that she wasn't listening, so I'm going to have to say that she didn't do what they told her to.
Now, after she fell, Emerson held her wrist like it was injured, correct?
Yes.
But you don't think that Emerson went, you don't know if Emerson went to the infirmary afterward, correct?
I wasn't there.
But you saw her later with a brace, right?
Yes, I did.
Now, according to you, based off of your perceptions, many of the guards didn't listen to Emerson Jones, right?
I don't know what you're talking about.
Many people at BJCI, to you, didn't listen to Emerson, right?
I still don't know what you're talking about. That was the same question.
Your Honor, may I approach the witness with her statement to refresh her recollection?
You may do so. What portion are you using for recollection?
Your Honor, I am using line 428.
Any objection?
None, Your Honor.
Okay.
May I approach the witness?
You may do so.
Please read line 427 through 428 silently to yourself.
I forgot my glasses. Sorry, I'm just... Okay, I think I got it.
So according to you, it seemed like nobody at BJCI listened to Emerson Jones, right?
If you're referring to the part where I said she whined about everything and nobody listened, then yes. But people listened to Emerson. I just didn't understand your question.
Well, that included the guards, right?
Yes, they didn't listen to her whining. They didn't listen to her in general.
Well, I'd like to ask you about your knowledge of Emerson's treatment. You don't know about her treatment at the prison infirmary, right?
You already asked me that. I said yes.
You don't know what her doctor diagnosed, correct?
Objection, Your Honor. This has been asked and answered.
Your Honor, may I respond?
Yes.
I did not ask about what her knowledge of the doctor's treatment or diagnosis of Emerson Jones.
If I may respond, Your Honors. Opposing counsel has asked about Ms. Healy's knowledge of the treatment before, and this has been asked and answered.
Your Honor, may I respond?
Objection is overruled.
Thank you, Your Honor.
You don't know what Emerson's doctor diagnosed, right?
I didn't even know she saw a doctor.
Now, you aren't testifying on Emerson's behalf today, correct?
That would be correct.
So let's talk about why. You are currently serving a 36-month sentence, right?
That's not why I'm testifying against Emerson.
I don't think you understood my question. You are serving a 36-month sentence at BJCI, right?
Yes.
And you still have 9 months left, don't you?
Yes, but I also have an early release hearing coming up soon.
Right, and you don't want to mess up your early release hearing, correct?
Would you?
So that's a yes. You don't want to mess up your early release hearing, right?
Well, of course not.
And you think that testifying for Emerson could mess up your chances of being released early, right?
No, Emerson has nothing to do with it. Like I said, the Supreme Court of Ohio is hearing it. They don't care about Emerson.
I don't think you understood my question. According to you, the most important reason you won't testify for Emerson Jones is because of your early release hearing, right?
Well, that wasn't the question you asked me before. Could you repeat that?
According to you, the most important reason you will not testify on Emerson Jones's behalf is because of your early release hearing, right?
That's the most important reason. Yes, but also, I don't want to testify for a liar.
Objection, Your Honor. I move to strike everything after the yes as non-responsive. I only asked about the most important reason.
Your Honor, Ms. Healy's trying to answer opposing counsel's question to the best of her ability.
Objection is sustained.
Thank you, Your Honor.
Thank you. No further questions.
Redirect.
Yes, Your Honors. May I proceed?
You may.
Ms. Healy, the issue of an essay contest was brought up. Are you over the result of that?
I don't know why everyone's making such a big deal about it. It has nothing to do with anything that's happening here today. Of course I'm over it.
So, has your relationship with Emerson at all affected your testimony today?
No, I'm here because I don't want BJCI to get in trouble for something they didn't do, like I did with my incarceration. I'm here to tell the truth.
Now, in the food fight, could you see the fight clearly?
Yes, very.
And what action did the guards take during the riot, food fight?
Well, pretty much what ended up happening is, after they came in, the fighting stopped.
And thank you. No further questions.
Any recross?
Yes, Your Honor. Now, as you testified on redirect, you don't want to lie for Emerson, right?
No, I don't want to lie for Emerson.
And you don't want to lie for Emerson because of your early release hearing, right?
I don't want to lie because lying is wrong.
That's not in your statement, right?
That's something
Objection,
that
Your
I
Honor.
feel.
This is an improper use of the deposition.
Your Honor, may I respond?
Yes.
The witness is allowed to reasonably extrapolate, but I am also allowed to clarify what is and is not reasonable extrapolation using the statement.
Your Honor, if I may respond, Ms. Healy can infer for herself that lying is wrong. She can make that inference.
Your Honor, may I respond?
Sure.
Of course, it is perfectly acceptable for her to make that inference, but I'm also allowed to test what is actually in her written deposition.
Overrule the objection.
Thank you, Your Honor.
Thank you. No further questions.
You can step down. Thank you. Does the defense rest at this time?
The defense rests, Your Honor.
At this time, I will allow 2 minutes for each side to prepare your closing arguments. If the timekeepers would be kind enough to keep track of the time for me, I'd appreciate it.
Right now, the students have a couple of minutes to prepare their closing arguments in the fictional case Emerson Jones versus Buckeye Juvenile Correctional Institute. Jones is arguing the institute violated her Eighth Amendment right to be free from cruel and unusual punishment when a guard fractured Jones's wrist during a riot and for improperly diagnosing that fracture as a sprain. The defendant, Buckeye Juvenile Correctional Institute, argues it did not violate the Eighth Amendment and it acted reasonably. After the teams deliver their closing arguments, the judges will adjourn for a short while to deliberate, during which time we'll have a chance to talk with some of the students participating today and get some of their perspectives. During that time, we will also have the opportunity to learn more about this historic building. When the judges are finished deliberating, they will come back in the room, give comments, and then announce the winning team. But first, we'll go back to the floor to hear the closing arguments.
Proceed at this point.
The defense is ready, Your Honor.
Ms. Cluse, you may proceed.
Thank you. May it please the court. Without responsibility, we cannot maintain a civil society. At BJCI, the guards were hired to protect and the nurse to treat. Yet neither met their responsibilities to Emerson Jones. We have proven that BJCI blatantly disregarded its duties and therefore violated the Eighth Amendment. Emerson Jones was merely a bystander in a food fight that has led to her suffering. Thrown down by a guard out of revenge, she was taken to the prison infirmary where her treatment was ignored. making it impossible for her to ever achieve full recovery. Today, the plaintiff has a burden of proof, and we have met that burden by proving two things. First, we have proven that BJCI was deliberately indifferent to Emerson Jones's serious medical needs. The nurse and guards could have known or inferred a risk, but disregarded it, failing to take reasonable measures. Their omissions led to an injury. We have also proven that Guard Menez's actions were unnecessary and wanton. He did not act in good faith to restore peace, but instead acted sadistically and maliciously. First, to examine deliberate indifference, the court must look to the Supreme Court case of Estelle versus Gamble. There, the court decided that deliberate indifference to a prisoner's serious medical needs violates the 8th Amendment. Emerson Jones testified that Guard Menez, a fully grown male, threw her to the ground by her wrist at the end of a food fight. She complained of her pain, but Nurse Rogers interrupted her and sent her back to her cell without treatment. Later, the nurse took an X-ray, and an anomaly was visible. However, the staff of BJCI then failed to take any reasonable measures to abate the risk. The U.S. Supreme Court ruled in Farmer v. Brennan that when a prison official fails to take reasonable steps to abate a subjectively known risk, the 8th Amendment has been violated. Dr. Lawrence testified that a fracture could not have been ruled out by the X-ray alone. Now, Guard Burgundy told Emerson Jones to tough it out, and Blair Healy even admitted that the guards often wouldn't even listen to Emerson Jones. Additionally, Farmer cited the earlier ruling in Rhodes v. Chapman, which held that when a prison official's acts or omissions result in the denial of the minimal civilized measure of life's necessities, the 8th Amendment has been violated. Faced with a cursory exam and no follow-up, Emerson Jones will never achieve a full recovery. Now, the defense has failed to provide a single witness or a single piece of evidence to rebut our claim that the nurse was deliberately indifferent. We have no testimony as to why she gave the diagnosis and treatment that she did. All we have is Emerson Jones's testimony that she seemed unconcerned and that the treatment plan never worked, and Dr. Lawrence's testimony that a competent medical professional would have followed up on the pain, limited motion, and the anomaly. We have also proven that BJCI's actions were unnecessary and wanton. The Supreme Court ruled in Hudson v. McMillian that cruel and unusual punishment does not necessarily have to result in a serious injury. Instead, the unnecessary and wanton infliction of pain, regardless of the extent of the injury, violates the 8th Amendment. This ruling was clarified in Wilkins v. Gaddy, which held the motivation of the guard is also a factor. Now, not only does Ms. Jones have a broken wrist, but Guard Menez did not act in good faith to restore peace. Emerson Jones testified that she was taken to the ground without ever hearing any warning from a guard. She was not even throwing food, yet Guard Menez still attacked her. He had no good reason to use such force. Guard Burgundy admitted that the food fight was not a riot, and Blair Healy admitted that much of C Block stayed out of it. However, the testimony today has made his motive obvious. Guard Menez has a long and brutal history of harassing Ms. Jones. He taunted her for nearly 4 years, gave her the long pants, and, when the right moment presented itself, he attacked her maliciously. Injuring Ms. Jones was nothing but an act of vengeance. BJCI has violated the 8th Amendment. We have proven the deliberate indifference of the institution. Both Guard Menez and Nurse Rogers failed to act responsibly by ignoring the risks that they saw before them. The unqualified nurse's indifference toward Ms. Jones will make it impossible for her to ever fully recover. Now, the clinic was poorly run, with insufficient equipment that supplemented Ms. Jones's diagnosis with only a blurry X-ray. Therefore, Your Honors, we, the plaintiff, respectfully request that you rule in our favor and find that BJCI violated the 8th Amendment. Thank you.
Mr. Venkata-Ramani, you may make your closing statement, closing argument.
Yes, Your Honors. May I proceed?
You may.
Your Honors, Mr. Waldroff, Ms. Kluth, may it please the court. In opening statement, my co-counsel, Mr. Gruber, described the two questions before the court today. Let us examine the first question. Did BJCI officials use excessive force in stopping the food fight? The answer to that question, Your Honors, is no. Guard Burgundy testified today that her job is to maintain order, and that disorder and chaos constitute the biggest dangers to both inmates and the function of the institution as a whole. In fact, Ms. Jones, Ms. Healy, and Guard Burgundy have all used the word chaos today to describe the cafeteria. And in the midst of this chaos, we even heard about the guard's order for inmates to go to the wall and sit down to avoid getting hurt or getting in trouble. We heard about how Ms. Healy obeyed this rule, unlike the plaintiff, who continued to be an active participant in the food fight. Now, the plaintiff's claim of excessive force is unsubstantiated for two reasons. One, according to a memorandum sent from the Ohio Youth Services Correctional Facilities to correctional guards, force is necessary to subdue an inmate, in this case the plaintiff, who refuses to obey prison rules, orders, or regulations. And two, Guard Mendez acted in a good faith effort to restore order. The Supreme Court ruled in Wilkins v. Gaddy that a good faith effort to restore order does not violate the Eighth Amendment. The plaintiff's rights were not violated simply because order had to be restored, and it was restored. Let us examine the second question. Did BJCI officials act with deliberate indifference to the plaintiff's medical needs? Once again, Your Honors, the answer to this question is no. After order was restored to the cafeteria and the food fight over, those who were injured went to the infirmary to be treated for their injuries, however minor they may have been at the time. The plaintiff went to the infirmary because she was involved in the use of force, but did not request treatment and left. A few days later, she asked Guard Burgundy if she could go back to the infirmary. And each time she returned to the infirmary, she received the same diagnosis, a sprained wrist. And each time she got that diagnosis, she was treated the same way. X-rays were ordered, and she was given ice, tape, and a brace for immobilization. She was even advised to rest and see her primary care physician upon her impending release from the institution. But we have seen today that she did not obey. Upon her release, she first saw her lawyer, who then referred her to Dr. Lawrence, and they met after a period of 2 weeks. And in these 2 weeks, she was responsible for her own care and delayed her treatment by seeing her lawyer first. Now, we argue the plaintiff was treated promptly for her injuries. The Supreme Court ruled in Estelle v. Gamble that substandard treatment may rise to the level of medical malpractice. But medical malpractice is a civil issue, and we are here today about constitutional issues. Ms. Cluse described the Farmer v. Brennan case. However, we are distinguished from Farmer in that Ms. Jones has created her own risks within the institution. And after careful consideration of the situation at hand, Guard Burgundy abated those risks to the best of her ability. Now, 3 witnesses who were present during the food fight have testified today. Ms. Jones was an active participant. Guard Burgundy was concerned with restoring order. Ms. Healy had one obligation, to go to the wall and sit down. And after she did that, she had a clear view of the plaintiff throughout the food fight and has told you the truth today. Your Honors, today we are here because the plaintiff claims she was maliciously and sadistically injured by Guard Mendez. But we have seen today that she is not exactly sure of that, because she told Dr. Lawrence that she may have injured her wrist when she was knocked down to the floor during the BJCI food fight. In that consultation, she never mentioned any guards. But today, we have continuously heard her complaints about Guard Mendez. She persists in accusing him of maliciously and sadistically, and without warning, injuring her. Ms. Healy told you today that she saw Ms. Jones trip and fall on her wrist. At best, one of the plaintiff's claims is not true, and the other questionable. And it is for the foregoing reasons that we respectfully ask this court to grant judgment in favor of BJCI and to dismiss all charges. Thank you.
Thank you. Ms. Cluse, you may make your rebuttal argument.
Thank you, Your Honor. May it please the court. The defense is right. BJCI has an obligation to protect the safety of its inmates. The guards, however, did not act accordingly. Now, Guard Burgundy admitted that even though she suspected gang activity, she never once separated the inmates. And Guard Mendez took extreme actions during a food fight, actions taken out of vengeance. Clearly, BJCI was deliberately indifferent in numerous ways. Now, opposing counsel mentioned Estelle v. Gamble. However, their analysis fails. In that case, the witness was provided with a doctor, a hospital visit, and there was no reason to perform follow-up. In today's case, Ms. Jones was denied proper medical care. The nurse saw an anomaly and then assumed it was probably just a mild sprain. Now, opposing counsel has called 2 witnesses, but these witnesses cannot even agree on Guard Mendez's use of force. While Guard Burgundy agrees that Guard Mendez pulled Emerson to the ground by her wrist, Blair Healy, with her overwhelming bias against Emerson Jones, claimed that she was somehow able to escape Guard Mendez, a fully grown male, and trip. Now, opposing counsel also used Farmer v. Brennan, but it also does not apply to the defense's case because the nurse, again, saw the anomaly and assumed it was inconsequential. How could a subjective risk not have been known? Ms. Jones came back to the infirmary with the same pain, and the nurse did nothing. The nurse ignored the obvious risk that was in front of her. Your Honor, Ms. Jones's indifferent treatment, in combination with the unnecessarily violent actions of a guard, has left her permanently compromised. BJCI is knowingly careless, blatantly irresponsible, and deliberately indifferent. We have proven, based on a preponderance of the evidence, that BJCI has violated the 8th Amendment. Therefore, we respectfully request that you rule in our favor and find that BJCI is liable. Thank you.
Thank you. At this time, the scoring judges will be excused to begin their deliberations.
Once again, you're watching the Ohio Channel and the 2015 Ohio High School Mock Trial Championship. We're coming to you from the Ohio State House in downtown Columbus. We just heard closing arguments for the mock trial case, Emerson Jones versus Buckeye Juvenile Correctional Institute. Arguing for the plaintiff, Emerson Jones, is Westerville North High School, and the defendant, the Correctional Institute, is being argued by Ashland High School. Right now, the judges have retired to do their scoring, and while they're doing that, let's talk again with Lisa Eshelman, the Executive Director of OCLRE. Lisa, thanks again for being with us.
Absolutely.
Now, that was really fun. That was really exciting.
Wasn't it exciting? We knew it would be a close trial, and certainly it proved us right.
Well, I mean, and you know, it's a good way of exploring legal issues and how the court system works, but it's also, there's fun elements to it too, like team veggies, team Big Macs, everything like that. So it was fun to play out.
It truly was, and that demonstrates that the students have put their own spin, whether it's on the facts or the theory of the case that they're arguing. They personalized it, and that's exactly what very good trial lawyers do.
Now, we saw a panel of judges out there at the beginning, and really only one judge spoke while the others just kind of quietly listened. Now they're in a room deliberating and scoring up the competition.
That's exactly right. We have one presiding judge, and he was the one that you heard from. He was ruling on the objections throughout the trial. The other 7 members of the panel are all what we call scoring judges, and their primary focus is to listen to the evidence and the presentations of the students. And so now they're all back in the jury deliberation rooms, talking about what they saw, talking about what they heard, and soon we'll have a new state champion.
And so the judges are going to come back and give their comments and opinions on how they thought the case played out. Can you introduce us to the judges that we're going to hear from soon?
Oh, I'm absolutely happy to do that. We have the Honorable Ed Sargis. He is Chief of the United States District Court for the Southern District of Ohio. He was appointed to the federal bench in 1996 by President Clinton. Followed there by Steve Jemison. He is CEO and President of the Law and Leadership Institute and formerly was Chief Legal Officer with Procter & Gamble. Followed by Judge Alan Goldsberry. He is a judge with the Athens County Court of Common Pleas, and for more than 25 years he has served as a site coordinator for the Ohio Mock Trial Program. Followed there by Drew Davis, and Drew is a staff attorney with the Ohio ACLU, American Civil Liberties Union. We also have Jonathan Shue, and he is an attorney with the Ohio Environmental Review Appeals Commission, and John serves as co-chair of this year's mock trial case committee. After that is Lee Bellardo. Mr. Bellardo is a lawyer in Avon, Ohio, but he also serves as president of the Ohio State Bar Foundation. The foundation is responsible for helping to improve the public understanding of the law, and certainly the foundation is a significant financial supporter of the Ohio Mock Trial Program. Judge Jerry McBride is who we saw as the presiding judge. He is a Court of Common Pleas judge from Claremont, Ohio, and serves on the Ohio Mock Trial Competition Committee. Followed by him is Jeff Ginsburg. Mr. Ginsburg is also a member of the Ohio Mock Trial Competition Committee and serves as personnel director for the Holmes County Court of Job and Family Services.
And so are there different awards that will be given out? I mean, we'll know who the winner is, but there are side prizes as well. Is that right?
There absolutely are. Just as we do for every trial that in which the students participate, the judges will determine the outstanding witness for the trial and also the outstanding attorney for this trial.
What goes into picking those awards?
Well, the judges look at a combination of factors. They look at the student's ability to put the facts to the legal issues that they're presiding and the development of the case as a whole. They'll also be looking at their skills in terms of the performance today, from their public speaking to the way that they made objections and responded to those objections as well.
And we saw a lot of those objections. They seemed ready on the ball, ready to go with those objections. Are a lot of these things cases and issues that they've already heard as they've done this competition throughout the months?
Absolutely. Remember, the students have been working on this particular case in September, and in order to get to this state championship, they have participated in 8 different trials. So by this time, they pretty much can anticipate what the other side is going to argue and what the objections are likely to be.
We're hearing a lot of excitement here in the room. Obviously, parents have been following their child through the competition. What kind of involvement do parents have in something like this?
We like to say the parents are key. When you think about the fact that they support their children every step of the way, so they're driving students to and from practices, they're listening to the students as they're rehearsing and getting ready, and of course they're the bones from everything from transportation to helping them feed them throughout the competition.
We saw when I was looking at the judges panel, a lot of the judges had big smiles on their face during different parts. It seems like they're really impressed by what they're seeing out of the students. Do you hear that a lot? Do you hear a lot of people who are impressed by this kind of competition?
Year in and year out, we absolutely do. And what's most gratifying for us is when you hear from judges who sit as judges on the bench in real life, when they'll say, I would put any one of these kids before me and against lawyers in the state of Ohio. It makes us feel like we're doing our job.
The dynamic of the witness is pretty interesting because it seemed like at some point the witness was being a little contentious with the other side. Is that some gamesmanship to try to throw them off?
It is. Just as the lawyers are able to anticipate what the objections might be, so are the witnesses. So they're understanding from the way that the question's been formed where the weaknesses in their case might be, and so they're trying to kind of cut that off at the pass, and that's where some of that contentiousness comes in.
Yeah, they're well seasoned. They've been doing this for a while now.
They do, right? It's kind of sometimes when you look at them, it's hard to believe that they're high school students.
Yeah. All right, well, Lisa, thank you very much for being with us again.
Oh, it's just been an exciting day.
So,
Thank
yeah,
you
it's
so
very
much.
great. Thank you.
Bye-bye.
All right, and so we're going to bring up a team now of students who competed today. Why don't you come on up here? And can you tell me your name?
I'm Ethan Gruber.
Ethan Gruber. And what side did you play today? You represented...
I represented BJCI, and I'm from Ashland High School.
Okay. And what kind of... Well, how do you feel, first of all? You just went through the state championship round?
The entire experience, we've had a long road to get here, and every trial seemed like a very close competition. So just the fact that we're here is amazing. So I want to win, but it's been a fun time.
Are you excited?
Oh, absolutely, yes.
Now, did you win the coin toss?
Yes, we did.
And you chose to be the defendant, is that correct? So is that your strong suit? Is that what you wanted to be?
It was a tough decision. We didn't really know what to do. Nobody wanted to make that decision, but then our legal advisor just said the defense is going, and we just went with it. So,
and how did you feel? What's that moment like when you don't even know which side you're going to be playing?
Oh, well, it was crazy. Just the way home last night, we were trying to figure out, because I'm a witness on the other side too, so I would be in it either way. And being the lawyer, you have more control, so it's more fun, but it's also more stressful. But it was still a good time. I was okay with being defense.
What's it like preparing for a case like this and then seeing another good team on the other side and trying to play off of them and argue the case?
We've been preparing for like 4 months, so we've had tons of preparation, and it's a better trial. It's a better experience when you have another team that's as well prepared as you are. Because when you play a bad team, it's not as much energy, it's not as much feedback. So the better trials, the better teams, that's what I'd rather do. It's a better competition.
Okay, great. Ethan, thank you very much.
Thank you.
Nice meeting you. Who wants to come up next? What's your name?
Lexi Portner.
Lexi, nice to meet you. And you played one of the head security guard,
Yes.
Is that right? Can you tell me what went into preparing for a role like that?
Well, it's guard Casey Burgundy, and it's just this hardcore prison guard. And so I had to go a little different than my personality, but it was a lot of fun to kind of take over that character.
It was kind of cool because you seemed pretty contentious with the other side, too. It seemed like you were trying to throw them off a little bit. Was that part of your game plan?
Yeah, it's a lot of fun to kind of mess with the other lawyer. It makes everyone have a good time. I think cross-exam's the most fun thing in the whole trial.
Now, how did you feel the moment before the coin toss when you didn't know what role you'd be playing and everything like that?
Oh, it was so stressful because I'm only on defense. This was the way I would get to compete in the championship, but nobody knew who we wanted to compete, and it was just up to fate.
And this is your first time in a competition like this?
This is the first time in the finals of state. Last year, our team did go to state, but we didn't make it this far, so this is huge.
How do you feel the team did today?
I think we all went out there and did really well, and I'm very proud of our team for getting this far and performing how well we did.
You practiced for this for months, but then you see a good team on the other side. Were there some curveballs that you weren't expecting that kind of threw you off a little bit today?
Yeah, there are always a few things. Each team brings something different. They have different legal advisors, different approaches. It's really just makes every trial super exciting.
Okay, great. Very nice to meet you. Thank you.
Thank you.
Who wants to come up next? Hi, and what's your name?
Hi, I'm Noelle Burke.
Noelle?
Yes.
And you played...
I'm Blair Healy. I'm an inmate at BJCI.
Okay, and what role were you going for with your character?
Well, essentially, we wanted to be thuggish but real, is what I was told. So we went with a kind of, you don't take crap from anyone, but you've got to tell the truth, and essentially you want to make everyone else believe your testimony more than anyone else's.
How do you feel the competition went today?
I'm very proud of our team. I'm sure everyone said that, but honestly, this is the championship round, and I think we definitely pulled out a personal best for all of us.
What did you feel like? I've been asking everybody this. What did you feel like when before the coin toss you didn't know which side was going to go up there?
Well, I'm actually a plaintiff lawyer as well as a defense witness, so I was not sure what to wear because I have to wear two different things, but it was just kind of stressful to see who was going, but I knew that either side that went, we would be confident, so that was good.
Did you have to run to the side and do a costume change at the last minute?
No, we had about half an hour, but I had to sprint, go change, and come back. So.
That's really cool. So your mind was prepared to play these two completely different roles?
Yes, I'm on the plaintiff, so it's two different cases, but I think it really helps you get familiar with both sides. I'm able to argue my side better because I know what the other side's thinking, so I really think that helps a lot.
Were there any curveballs that the other side threw at you that kind of threw you off guard?
I don't think anything really threw us off. We're kind of prepared for all the curveballs. We've been doing this for 4 months now. I think everything that could be expected did happen, and I think we were pretty prepared.
Okay, great. Nice to meet you. Thank
you.
Can you tell us your name?
Hi,
I'm Bharat Venkataramani, and I was a defense attorney.
Now, you were on the ball, especially at the beginning, calling up all those objections and everything like that. So you've been doing this for a long time. So were you ready for a lot of the things that the other side threw at you?
Yeah, we marked the depositions, like where's everything objectionable. So we're just really prepared for those things.
How did you feel before the coin toss, not knowing what side was going to go up? Were you playing a different role on the other side?
No, I'm just an attorney, but we're actually talking about this, what happens during the coin toss, and we're just wondering, what if we have to make a decision? So as soon as that came up, I was just saying, guys, I'm out of here. I'm not making any decisions. But, I mean, our legal advisor said, all right, defense is going. So I said, all right, now I'm at the table.
So are you just the defense attorney, or would you have been an attorney on the plaintiff side too?
I wouldn't have cared what side I would have been. I was just done the attorney role.
So how do you feel about the team's chances today?
I really don't like to speculate, but we did extremely well. It's personal best for all of us. We just left everything out there.
All right, great. Thank you very much. Nice meeting you. Hi. Can you introduce yourself?
Yeah, my name is Alex McMillan.
All right. And you are with Ashland?
Yes.
But you didn't get to compete today?
No, sadly I didn't, but that was a great trial, so I don't mind too much.
So you would have been, what role would you have played if you were on the plaintiff side?
I am one of the attorneys on the plaintiff side.
Okay. How did it feel when the coin toss happened and you didn't know who was going to go up there?
I'm going to be honest, I was kind of hoping that the other team would win and they'd get to pick, because nobody on our team wanted to pick who was going on. So, I mean, it's okay. I understand.
So you're an expert on the plaintiff side. How did your competitors do today?
Well, it was kind of funny because most of the points they brought up were points that we were going to bring up if we were going to be the plaintiff in this case. So I thought they had a very good argument, and this was a fantastic trial. This is probably the best trial we've had at state.
Probably works out for your team then, because if the plaintiff side brought up a lot of arguments you would have brought up, then they're used to hearing that argument and can kind of defend that a little bit more?
Yeah, some of the questions we had gone over, but some of them were also curveballs that we'd never heard before. So I thought it was just a good thing for everybody that participated.
All right, great. Alex, thank you very much.
Thank you.
Hi. Can you introduce yourself?
My name is Katie Vostacek.
And you would have been playing what role if you were the plaintiff?
I was a witness. I would have played the teacher, Taylor Caputo.
Okay. And how did you feel before the coin toss, not knowing which side was going to go?
A little stressed out, a little nervous, because you always prepare yourself to go. And yeah, so I was a little nervous up into the coin toss.
Is that how it always plays out in these competitions, or is that just in the state championship?
In this round, yes, it is done by coin toss. Typically in the rounds up until now, especially in like the final four, the 8, after it's done, if all plaintiff sides or all defense, they do have to repick who goes next.
So you had a front row seat to the entire competition. How do you think your team did?
I think they did very well. I have full confidence in them. It's one of the best trials that we have done by far so far.
All right, great. Thank you very much. Nice meeting you.
Nice meeting you too.
Hello. Hi. Can you introduce yourself?
I'm Joy Day. I'm the advisor of Ashland High School.
All right, well, first off, how do you feel about your team today? How did they do?
Super. Couldn't ask for anything more.
And so I've been asking everybody this. How did you feel when the coin toss happened? Nobody knew who was going to go up, and
I was just hoping they were going to win the coin toss so they could make that decision. I didn't want it. But
what kind of preparation goes into a mock trial like this?
We start in November. So you go through November, December, January, February, and now here we are in March. And this goes longer than a sports season.
And I'm guessing it's mentally taxing trying to look at everything from all angles and really prepare yourself on the argument?
Not taxing. I would say it's challenging. And that's, I think, what the kids like about it, certainly what I like about it.
What do the kids get out of this? Because obviously they gain a whole lot of legal knowledge and some like drama skills as well. So what do the kids get out of this?
Basically, they learn speaking skills, they learn critical thinking skills, they learn how to think on their feet. I mean, you couldn't ask for a better program than this to prepare for one's life adventures, I think.
Okay, great. Thank you very much. Nice meeting you. Hi. And what's your name?
Howard Glick.
And what do you do?
I'm the legal advisor for Ashland.
Ashland. And so Ashland got to be the defendant in the case today. How did you feel when you found out that was the team going up there?
We felt horrible that we had to make the choice. I mean, it was our choice. It was like the movie Sophie's Choice, where we had to give up one child for the other. Either team was as good, but we just had to make a choice, that's all.
How do you feel about how your team did today?
Wonderful. I mean, the whole 2 days has been a real experience. This round is as good as any other round we've had, but the experience, of course, in the courtroom and the 8 or 10 judges is pretty awesome.
It was fun to see the witnesses kind of give the other team a little grief here and there, a little gamesmanship and contentious. How does that play into it?
Well, you're defending your position. I mean, that's what each witness is told to do, to tell the truth. And you know, the cross-examination of a witness is we always say it's the effort of proving the witness either a liar or an idiot. And you don't want to be proven either. So that's how it works.
The two attorneys up there seemed very well versed in legal issues and everything like that. Do you think they have careers as attorneys in the future?
We're not here to train these kids as attorneys. I always tell them it's to get confidence standing on your feet. You're going to have a job interview or a college interview. You're going to propose a project. You're going to ask for a proposal to be passed. 4 years from now, 5 years ago, from now, whatever you're doing, you may realize that it was because of mock trial that you're successful. So that's why we do it.
Okay, great. Thank you very much. Nice meeting you. Come on up. You're Emerson.
I am.
What's your real name?
My name is Amy Cox.
Okay, and how did you feel being able to play the role today?
Well, it definitely was a lot of work. I was really excited to be here. Our school actually hasn't made it this far ever before, actually, I think. So being able to support my team and my friends was really cool.
What kind of preparation goes into being a witness and going up on stand and having to know all the facts?
Well, you lose a lot of Saturdays, that's for sure. You have to not only know all of your statement, which for us was about, I think, 3 pages, but you also have to know actually the legal terms behind it, just because you're part of the team. And so part of the event is that people tell you like how to do like case law and how to do objections, and we don't use them, but we still have to know them.
And you had to know and be prepared for what the other side was going to ask you at any moment.
Yes, exactly. We had quite a lot of our half going against the other half to see which objections we could make up and see how far we could push ourselves.
Who came up with the whole Team Veggies, Team Big Macs thing? Was that your team or was that part of the scenario?
That was actually in the statements.
It was in the statements, okay.
Yeah.
All right, so that was, I mean, it's fun because you have this, what seems to be a pretty good legal argument, but then you have some fun things here and there that you can play around with.
Yeah, I absolutely agree. This case was really entertaining. I really liked all the facts, and they definitely made it an enjoyable experience.
So what do you think of your team's chances?
Hopefully we did pretty well. I think every single one of my team members put their heart out into it. I was proud of everyone, and win or lose, I mean, we have so much support behind us. I don't think it's about the winning. We'd like to win, but honestly it comes down to we gained an amazing experience.
Were there any curveballs that the other team asked you that you haven't heard before or that you didn't see coming?
Not particularly. We did quite a few matches, so I've heard pretty much all there is to say, I think. But they definitely hit a few points I wasn't used to. I've heard them before, but it's just getting in that mode of learning everything. So.
Okay, great. Thank you very much.
Thank you very much.
Hi. And can you say your name?
My name is Matt Spadero.
All right, and you played the doctor in this?
Yeah, yes, that's correct.
And how do you feel about your team's performance today?
I think that was probably one of the best rounds that we'd ever done in our lives. I mean, we couldn't have asked any more from ourselves. I think we did amazing.
What do you need to do to prepare for your role as the doctor? Because obviously you have to play an expert in the case.
Yeah, well, there was a lot of terms in the statements that I honestly just did not know. So it was a lot of like looking up definitions, looking up exactly what things were, and having to do a little bit of outside research to understand exactly what the statement was saying.
And you have to be ready for what the other side's going to say, what the other side's going to object to. What goes into preparing for something like that?
Well, a lot of the times we have the attorneys make up just crosses on the spot, or we have our coaches just do some random crosses, and that always helps us to prepare to just expect anything. So that's usually that's a big part of the preparation that we do.
Okay, great. Thank you very much. Hi.
Hello.
How are you? And what's your name?
My name's Jacob Waldroff.
All right. And what do you think of how your team did today?
I think we did really well. I wasn't really unhappy with anything we did, and I think we did everything to the best of our ability.
What do you think of the other team? Because it seemed like there were two pretty strong teams going against each other.
Oh yeah, they were great. Probably the strongest team we've faced so far.
What kind of preparation goes into something like this?
There's a lot. We practice all the time, have extra practice with our coaches, and it's fantastic.
And what do you want to do after high school? Do you want to go into a career in law, or?
I've considered it, but I don't think so. Yeah. I'm thinking more the biology route of things.
What have you gotten out of this experience? What's your takeaway?
Honestly, the biggest thing I've gotten out of mock trial is just being more confident and being able to think on my feet more, I think.
Okay, great. Thank you very much. Nice meeting you. Right, next up. All right, and what's your name?
My name is Jacqueline Cluse.
And you were a co-counselor for the plaintiff.
Yes, I was.
What kind of preparation went into preparing for a role like that?
I mean, it's months and months of work, but it's all fun. I think that's what makes it really great, is that it's so much work, but I enjoy all of it. You know, it's about expecting the unexpected, I guess, being prepared for anything.
And how do you feel that your team did today?
I could not be more proud of them. They are so fantastic, and I couldn't ask for a better team.
Okay, great. Thank you very much.
Thank you so much.
Nice meeting you. Well, as you know, the room we're in right now is a hearing room for the Ohio Senate. The Senate building is connected to the Ohio State House through the atrium, which was constructed in the 1990s. And these three buildings, the State House, the Senate building, and the atrium, comprise Capitol Square. Since we're here live to you at Capitol Square from this historic location, let's take a moment to learn a little bit more about these buildings. The Ohio Channel's coverage of the 2015 Ohio High School Mock Trial Championship will resume in a few minutes.
The Ohio State House was completed in 1861 at the beginning of America's Civil War. The State House is considered to be one of the most significant architectural accomplishments in the early Republic. Its Greek Revival Doric architectural details and proportions give the impression of permanence, elegance, and grandeur deserved by the original state legislature, who passed a law on January 26, 1838, to build the new State House. Restored to its 1861 appearance, the Ohio State House maintains its historic character as it continues to function as the center of state government in Ohio. The Ohio State House is situated on a 10-acre parcel of land that was donated in 1812 by 4 prominent Columbus landowners. The State House is upon foundations 18 feet deep, built in part by prisoners sentenced to labor. The State House features a central recessed porch with a colonnade of a forthright and primitive Greek Doric mode, built of Columbus limestone that was quarried on the west banks of the Scioto River. A broad and low central pediment supports the drum-shaped cupola, which contains a skylight that lights the interior rotunda. Unlike many U.S. state capitol buildings, the Ohio State House owes little to the architecture of the United States Capitol. It was designed and built before the U.S. Capitol was enlarged to its present form, with a large white dome that would become ubiquitous on government buildings in America. The Ohio State House has been termed a supreme example of Greek Revival style. Because the city-states of ancient Greece were the birthplace of democracy, this style had great meaning in the young American nation. Greek Revival is simple and straightforward and looks nothing at all like the Gothic Revival buildings popular in Europe at the same period. The broad horizontal mass of the building and the even and regular rows of columns resemble such buildings as the Parthenon in Athens. No ancient Greek building would have contained windows, but they were a major part of Greek Revival for a more practical reason. Before the electric light bulb, sunlight was the major source of illumination. More than a century and a half old, the Ohio State House has been designated a National Historic Landmark by the Secretary of the U.S. Department of the Interior. This honor recognizes the long history of the building and the continued role it will have in the life and lawmaking of the state of Ohio.
Surrounded by brilliantly white marble, you're standing in one of the most impressive spaces in the Capitol Square complex. It is enclosed by a ceiling of detailed murals, which surround a stained glass Great Seal of Ohio skylight. Before the massive renovations during the 1990s, it was not known that there was a skylight in this space because it had been covered from the inside and outside with pieces of plywood. Restorers speculate that the skylight had been covered because it was in such a state of disrepair that it leaked and might possibly fall out. It has since been repaired and secured. As you gaze upward, you'll notice the murals on the ceiling of the Grand Stair Hall. These 4 murals represent art, justice, manufacturing, and agriculture. Each painting shows a woman holding various related objects. Also used for decoration in the Senate building is gold and aluminum leafing. Although the gold leafing appears to be quite prevalent, there are only slightly more than 3 ounces of gold in the building. Today, the Senate building is home to 31 of Ohio's 33 senators. The Senate President and Senate Minority Leader both have offices in the State House.
I hope you enjoyed that virtual tour. You can find many more State House tour videos at ohiochannel.org and on iTunes by searching for Capital Ohio. We have a few more students here to talk to us about their experience this morning. Can you tell us your name?
My name is Diana Asta.
And what role would you have played?
I would be playing senior guard Casey Burgundy on Westerville North's defense.
All right, so since Westerville North played the plaintiff side, you didn't get to go up there today. How did it feel before the coin toss happened, not knowing what side was going to go up?
It was kind of hard stopping. We weren't sure which side was going to be playing, and I know each side was very prepared and excited to go. So it was a little sad that we weren't going to be able to portray these characters one last time, but it was very fun, and I had so much faith in my team.
Now, you had the experience of seeing somebody else on the other side play the role that you play. How did that feel? What did you think?
It was strange. I had seen multiple senior guard Casey Burgundy throughout the competition, and she played it differently than I had ever seen someone play it before, and it was refreshing to see someone take a different stance than I had before.
Okay, great. Thank you very much. Nice meeting you.
Thank you.
Next up, can you tell us your name?
My name is Jennifer Finkelstein.
And what role would you have played today?
I would have played Nurse Robin Rogers, who was the witness that wasn't called today on the defense.
Yeah, I found that interesting, and we were talking about this earlier. So how many witnesses are available?
There are 3 on each side that's available, and then the attorneys and witnesses, the teams work together to choose the 2 that they think are best for their case.
Yeah, so they pick and choose to decide how can they best argue their side?
Yes, yeah.
And so we didn't get to see what the nurse would have said. What kind of perspective would you have brought to the case?
It was a little upsetting for me that I didn't see it, but I really liked what they did with Blair and the Burgundy, but I think I could have brought a little bit more of the medical opinion too, so it all worked out though.
How do you feel about your team's chances today? You got to have a front row seat to see them.
I'm excited. I think either way it was a wonderful trial, and everyone was obviously so prepared and very ready for this, so I'm not sure, but I'm excited.
What do you take away from an experience like this, working so hard to prepare for a mock trial?
Well, I'm a senior, so this is my last year, and I guess you really realize that hard work does pay off. We've been competing and trying again and again each year to get as far as we can, and this year we got here and we've never made it this far, and so it's really nice to see that.
Okay, great. Thank you very much. Nice meeting you. All right. Can you tell us your name?
Yeah, my name is Tristan Justice, and I'm an opener for the defense.
So you unfortunately didn't get to go up today, but you got to see your team in action. How do you feel about their chances today?
Well, I was a little disappointed that I didn't get to go today. I was really happy with how our team did. I think both teams did a great job, and I can't wait to see what the result is.
And again, you had the rare chance to see your competitors play the side that you were preparing to play. How do you think of how they did, and what would you have done differently?
They did a good job. I don't think there was much that I would have done differently. I think both sides, again, did a tremendous job.
And what's a big takeaway from preparing for a mock trial?
Well, what I've taken away from it, this is my 4th year now, and it's really helped me in my ability to think on my feet and in critical thinking, which will certainly help me in my future. So.
All right, great. Thank you very much. Nice meeting you. Hi. And what's your name?
I'm Tiffany McCutcheon.
And you would have also been on the defense side. What role would you have played?
I would be a defense closer, and I also direct senior guard Burgundy and cross Emerson Jones.
And how did you feel before the coin toss, not knowing if you were even going to go up at all?
Well, I was definitely nervous because, I don't know, it seems kind of like scary to get on and perform in front of a big old crowd, but it didn't matter to me. I feel like both sides of the case are strong, and whatever happened, we would be okay.
And what are some of the big takeaways from preparing for a mock trial like this? You learn a lot of legal information, but I'm sure there's more to it than that.
What definitely is the big thing for me is public speaking skills. Like, it's helped me become so much more articulate in what I do and everything I do. And also it just gives me a great work ethic. So much work goes into this, and this just helps so much.
Okay, great. Well, thank you very much and good luck. Well, the judges are going to be entering the room at any time, so let's get ready to hear what they have to say.
Before we begin with the debriefing portion of this, I just want to congratulate both teams. It was a very splendid competition. Both teams really did a great job. And we will start at this end. Jeff?
Thanks, Judge. Well, this was a real pleasure for me. I had been here for the final round for many years and had missed the last few years, so it was a real privilege to be back and see the two best teams in the state. You really earned your right to be here, and I think it's the first time to this stage for both schools, so congratulations. I really don't have many comments. I thought everybody did everything well. I thought you had good, consistent themes throughout your trials. I thought you were skilled in your objections. I liked the way you so quickly recovered when objections were sustained. The witnesses stayed in character. If I had any very minor, comment, I thought some witnesses were maybe a little too argumentative, but they were in character, but I still thought you were pushing the envelope sometimes on how argumentative the witnesses were. I particularly liked the way you, Ms. Cox, didn't let the attorney control you, but still weren't too argumentative in my perception. But anyway, I thought everybody was fantastic, and congratulations again.
Yeah, so again, congratulations on making it this far. I think you should both teams should be very, very proud of making it here. This is my first year judging the final round, and I was definitely very, very impressed by the quality of both teams. I thought this was a very difficult case. The facts were pretty complicated, and they don't quite line up in all the places, and it's on purpose. At least that's what we're going to claim. They're on purpose anyway. But you guys did a really nice job, I thought, sort of handling those types of issues and really framing the issues in the case very clearly. That's one of the things that is very helpful in real life cases as well, and that a lot of times real attorneys struggle with is, okay, what exactly is it that I need to prove? And then maybe real briefly, the most impressive thing I thought was that at least maybe 3 or 4 times during the trial, in my notes I said, pick the right place to sit down. Learning when to shut up is one of the best things that you can have, and so I thought that was great. So congratulations, guys.
I'd be remiss. Excuse me. I'd be remiss not to also thank your advisors and your teachers and legal advisors and teachers, coordinators for preparing you for this. That must be a great endeavor to see you grow from the beginning. Probably you all started probably in November or October with this case material, and those advisors and teachers were with you from the beginning, and I'm sure they saw you grow from those early days in the fall to what you just did today. You should thank them tremendously, and the parents as well who are sitting in the audience. The one thing that that stood out in my mind about the trial was the defense's tie-in from the opening and the closing. Excellent job. Both teams did it well, but because you're a team and the opening attorney doesn't do the closing, it's excellent to see that tie-in between the opening statement and the closing argument. Thank you, Judge.
So I want to congratulate both teams. This is my first time judging a mock trial competition, and what a first impression. My goodness, my congratulations to everyone involved, including your teachers and legal advisors. Excellent themes on both sides. Just incredible cohesion throughout, and also very cogent objections. And the other side persevered through those objections. So excellent job from everyone.
I want to echo all those comments. There are 3 of us up here who are trial judges, so we see lawyers oftentimes performing. And I can say you would stand with the best the way you performed today, which also makes it very hard for us to grade you, because I want to tell you ahead of time that we think of all 4 of you as very, very close in terms of your abilities. I also teach a trial practice class at the Ohio State Law School. If I were grading all 4 of you, I would give all of you A's, I can tell you that. I thought your first of all, your speaking ability is outstanding. That's always a big plus. When you're doing trial work, I thought your opening and closings were very, very good and very linked together with the rest of the trial. What is hard to teach is effective cross-examination, but I'm very pleased how well all of you have it down. You know how to ask the leading questions on cross but not direct, and you also are very good at making sure witnesses don't evade your questions. All of you were very tenacious about not letting a witness give an answer that they wanted to give that didn't respond to your question. That's a hard skill to learn, and you already have it down, and I'm very impressed. So it was great to listen to all four of you. It's just a shame to have to grade all four of you.
I'd like to first express my thanks to the mock trial program and the Ohio Center for Law-Related Education for giving me the opportunity to be here for the finals. I've been in district competition for many years, and I've come up here for the Friday sessions as well, but I never made it to this round, and it's been a real thrill for me. In case you're interested in what I would see as differences from the levels, of course it gets better as you advance overall in general, but 2 or 3 points that I would note is a lot of times in the earlier sessions, objections will look like they're sort of contrived, or that you feel you have to make an objection, so you make one without thinking real well about why you're objecting and whether it's important to the case or not. But everything that happened here seemed to me to be either well planned, or something happened from the witness stand that required you to make an objection, and so you did so. Also, objections were more vigorously pursued than I have seen, because several times we had maybe a total of 4 comments by counsel on individual objections. Sometimes judges won't allow that, but they did here, and the follow-up comments were always, I thought, very good and very thoughtful. Like, I forgot to say this the first time, I do have another reason besides the one I used before. So that's to your credit. Also, if you're losing an argument, I noticed a couple of times individual attorneys here said, I withdraw the objection. And if things are going badly for you, oftentimes that's the very best thing you can do, is to say, I quit, I've made my point. And that was done very well here. It was a high quality arguments on both sides. Your schools, your communities are to be congratulated, and especially your legal advisors and your faculty advisors for what they do. You know, this program is not designed to interest people in going to law school. But I have noticed over the years that a number of people that have been through the program have gone to law school. And in their first 2 or 3 years of law practice, I've noted that maybe the first time I'd see a lawyer, he or she would mention to me that, you remember I was on such and such a team 5 years ago. And they're proud of their participation in it, and obviously it makes an impression, although I know it makes an impression even if you go on to other careers. So I thank you all for letting me hear your presentations today, and I congratulate you.
First of all, I would say for me anyway, it's an honor for me to be here, to listen. You guys are so skillful, so smart, so articulate. It's just humbling for me to be in your presence. You were all terrific. And then when I mean, obviously we have to sit down and figure out scoring, and it's like, I use a razor for my shaving my head, and the difference between the teams is narrower than the razor that I use. So, I mean, and the other thing is, yeah, your advisors should be congratulated, but you didn't get here by yourself. And you have your parents and probably some others in your family to thank for the success that you've achieved. Don't forget to thank them. It means a lot. Obviously, this is not like T-ball, so there has to be a winner and a loser. But there really isn't a loser. The skill that we saw, that we observed today, and the difference is so minor, but the skill was just amazing. So I'm really grateful, Lisa, that you invited me. Thank you.
Can you give me just a second? Outstanding attorney and outstanding witness awards were very difficult to give in this trial because all of the witnesses were very good, very believable, played their parts well. I think I had a number of good things to say about the case, but I thought the variety of roles among the witnesses this year was as good as I've seen in any of the mock trial competitions I've been part of. So I think the case committee did a superb job, and teams did a superb job. I feel like those witness roles and witnesses, how they perform. So it's not easy to make these selections, but the outstanding. Not really. Can you hear me now? Okay. Probably is a balance here, right, between too close and too far away. The witnesses did a great job. I hope all of you heard that, and I think every witness was very believable as far as I could see, and the roles were a variety of roles, and so I think the witnesses did a super job. And the outstanding witness, we had to select one, and that is Matt Spadero. And the outstanding attorney is the same way. All four attorneys did a great job. The objections that were made during this trial and the responses that you had to the objections were generally just right on point. And the objections generally were made regarding matters that did affect your case. And so I thought the objections were very good, but everything that you did in terms of your direct and your cross and your openings and closings were very good also. Very hard to select the winner of this also, but the outstanding attorney is Ethan Gruber. In terms of, I know you want to know who won the competition, right? That probably is something that's on your minds a little bit. This point, I've done this a number of years, been fortunate enough to be able to participate in the championship round, and it's always an awesome experience to see what you as students are able to accomplish and what you have done in benefiting from this program, because I think it's a great program. And you wish that you could say and sometimes scoring judges do this, not in this trial, but sometimes you wish you could say both teams win. It's a tie. But we can't do that, and obviously this is a competition. It's a learning program also, and you all have benefited from that. And I think you need to keep in mind that when this competition began, there were 329 teams, and we are here with the final two. So one team is going to finish first, one team is going to finish runner-up, but obviously both teams were excellent to get to this level. And hopefully all of you appreciate that when you leave here today. But again, when we train scoring judges, we tell them you can't have any ties. There are no ties in this. So, and there are 7 scoring judges so that we don't have a tie among the scoring judges. And the team that is the winner of this year's competition is Westerville North. Right? If you, teacher advisor, if you go ahead and introduce your team members. Yeah, please use.
This is an interesting time to have to do this, but all right. So I'm just going to go through who we have here. Opening for the plaintiff, we have Jacob Waldroff, senior. Closing, we have Jacqueline Cluse, senior. Playing Emerson Jones, we have Amy Cox. Playing Dr. Lawrence, we have Dr. Matt Spadero. Opening for the fence, we have senior Tristan Justice. And closing for the defense, we have junior Tiffany McCutcheon, and our team captain as well. And then playing Nurse Robin Rogers is Jennifer Finkelstein, senior. And playing Casey Burgundy, we have Diana Asta, junior. We also have our attorney understudy, Jeffrey Rhodes. And we have our timekeeper, Amanda Lamb, freshman. Call it the advisors as well. Do you want me to call it the advisors as well? Okay. We have our first-year legal advisor, and one of the main reasons we're here, Scott Longo. We have teacher advisor, Tom Pete. And then we have the heart and soul of Westerville North for the last 20 years, mock trial, Ken Gonchatz.
High School. I'd certainly like to introduce to you our entire team. Bharat Vikramani, Ethan Gruber, Lexi Portner, Noel Burke, and two wonderful students you didn't get to see today, Alex McMillan, Katie Fotsacek, and our outstanding bailiff, Bobara. To call up my right-hand woman here, Lynn Wells, teacher advisor. And the heart and soul of the Ashland team, our attorney, Howard Glick.
Again, great job by both teams. I know it's reached this point and it's tough not to do the championship, but both teams, I think, were championship teams as far as I'm concerned. Really was extremely close.
You've been watching the Ohio Channel's coverage of the Ohio High School Mock Trial Championship competition. Congratulations to the winning team, Westerville North High School, and also a big congratulations to Ashland High School, who put up a great fight in this championship round competition. Westerville North High School will head to the national championship in Raleigh, North Carolina. To purchase copies of this program or to view it online for free, visit us on the web at ohiochannel.org, where you can also view live and past video coverage of your Ohio government, including the Supreme Court of Ohio. Thanks again for watching, and we'll see you next year.